Lordship, I have filed an interlocutory petition, my lord, to correct only one
Correction.
word. Yes, one similar.
Correction.
Similar prayer.
Correction. Correction, yes, otherwise no.
Yes, correction. I'm filing an alternate petition, my lord.
What is the
The
urgency?
petitioner was working as graduate teacher since last 30 years. He has been sought to be reverted back to the post of LDA by an order dated 9/10.
It's after a proceeding or before a proceeding?
Reasonable court
No, reversion is after a disciplinary proceeding.
No proceeding was initiated. Can it be taken up tomorrow, my lord?
Get it today.
My
My lord,
What is your urgency? Yes, yes, Mr. Dhar is
my
waiting
lord,
for long
with the
time.
consent of the other side, Mr. Dubey, I'm seeking an adjournment for 9 and 10.
Okay, on the prayer, Mr. Adhol and counsel, for whom do you appear, Mr. Dhar?
ED, my lord, enforcement director.
For the adjourned.
My lord, in-service doctors, my lord, file one writ petition regarding, my lord, the illegal counseling at, my lord, today at 12
Sorry.
noon, my lord.
Hmm?
In-service
Okay,
doctors, my lord,
doctor filed repetition for what?
my lord, regarding admission to the post-graduation course, my lord, and counseling is immediately held, my lord, today at 12 noon, my lord.
So what do you expect
My lord, lordship may consider it, my lord.
right now? Give it. Give your petition.
My lord, my
No,
lord,
no, right now.
I have filed, my lord, it will come, my lord, within 1 hour, my lord.
How do you know it will come within an hour or not?
I have already filed.
Because there is a procedure. Even if I allow, there will be a production list.
Yes, my lord, it will come, my lord.
How do you know? Do you manage the registry?
Yeah, yes, my lord, I have already filed, my lord.
No, no. Do you manage the registry that you know it will come?
Well, I'll try, my lord.
Means you have some control.
No, my lord, I will go
Then
there.
how do you know it will come
I'll try, my lord.
before 12 o'clock? For today,
Yes,
for today.
keep you.
But with the consent of the other side, I beg to mention item number 3 of today's day, my lord. This matter regarding PSG cancellation, my lord. Last occasion, my lord, has called for the record, whatever he has done, my lord. We have received the records, my lord, yesterday, my lord. We need some time to.
What record? Your record.
Oh, yes, my lord. What
Adjourn
record?
on the prayer. There is no interim order, I think.
No, no, no.
Adjourn on the prayer, Mr. S. Hazoria and council petitioner.
Can it be on Monday, my lord?
Monday, we don't know.
Can it date maybe, my lord? Any date?
After vacation. After get out.
Obliged.
8 November.
Wait, please, Mr. Lordship. My lord, I beg to mention item number 7, my lord.
7.
My
One adjournment.
adjournment.
For whom do you have? Petitioner or
Petitioner, my
name Gwala?
lord.
John HP Gwala. Yes.
Maybe your lordship, beg to mention for listing a WPC of 2016, your lordship. Actually, it is a study center matter. KK Hendrik State Open University had
Give it
provided.
After the vacation.
license. Your lordship is very urgent, your lordship, because just.
If it is a 16 matter, why it is not mentioned for in 17,
No, you're-
18, 19, 20, 21, 22? And 23 also, why is it in the end of October now?
No, your lordship, I just see.
Sorry, you were rejected.
It was last
Uh,
posted on 25/8/2023, your lordship. It was last posted on August, your lordship. August
It
2023.
doesn't matter.
Please fix it tomorrow, your lordship.
No,
Next week, your lordship.
after
Just-
the vacation. Please. You have to bear with the system also.
Okay.
One individual man all of a sudden falling from heaven and say, today is my urgency. We can't entertain that.
Lordship, I beg to mention WBC for listing matter on
Where is the urgency? On?
19 October. Actually, Lordship case was listed on 31st March 2023. And supposed to be listed after 4 weeks, but not listed.
19 October will be difficult, madam. After the vacation, we'll take it up. Please give the memo, it will be listed. Yes, ma'am. Not, other madam.
To mention for listing of a matter for admission, Lordship, after vacation.
After vacation, give it.
Please, Lordship.
Wait, please, your lordship. I beg to mention for listing of a writ petition tomorrow. The urgency is that the petitioners are the qualified teachers of 2017, but they are not allowed to participate in a subsequent advertisement.
When is the last date of the advertisement?
It was published in 20.
No, last date of submission of application, when is it?
I think it was in the month of February.
Month of February. What to do? Not tomorrow.
Then lordship next week, any day.
After the vacation, you bring it, we'll take it up.
Okay.
Item 12 and 13 with 13 and 14 with personal appearance.
13 and 14.
Order. Order.
The SBI has been RTI reply lordship.
What is this?
Regarding this is the statement prepared by that person, the SBI lordship regarding the whole case. That they,
No.
as per the RTI.
No,
information
there
that-
is already a judicial order of 12/5/2023.
Yes.
Come to that order, please.
Okay, question, yeah.
Paragraph 8, you come to almost the 10th line.
Lordship, so sorry, but I have to get that order.
এখন video পড়ো। Read the 10th line.
Paragraph eight.
Almost 9th or 10th line, just see as to how. Paragraph 8.
Yes.
9th or 10th line of paragraph 8.
As to
In the middle of the sentence,
Yes.
as to how.
As to which proposal,
No, not that, as to how.
as to how under RTI, a different.
Ha,
document
slow,
presently-
as to how under the RTI.
A different document presently stated to be not available
Ha,
in the record.
This
of
is
the
where we are concerned.
Deputy Commissioner.
Under the RTI,
Yes.
a document was given to
Yes,
the
yes, yes, that is.
RTI applicant,
Yes, sir.
which did not exist in record.
That
This is a little disturbing.
Yes, yes. What happened? Lord?
We have, today is fixed only for that purpose,
Yes, yes.
not on the merit of the case, not on the,
Yes, yes.
on any other issue. Why under the RTI, a document was given which is not on record?
Yes, exactly.
You explain that.
Lordship, that district scrutiny committee has first is submitted his minutes on 29/11/2017. That is the first minute from the district scrutiny committee. Where Lordship, when that SLC chief Lordship, they found that in 2 pages, there is no signature on the district.
No,
Yes.
we are not trying to
Yes.
justify it.
Yes.
We are asking,
That is what I'm saying, Lordship. That is what I'm saying.
what you are trying to say?
Then the director has returned back that district scrutiny committee to the deputy commissioner for authenticate that last 2 pages, whether that 2 pages are correct or not. Then instead of sending that proposal, the first proposal, Lordship, that deputy commissioner has sent a second proposal on Lordship's Lordship on 26/11/2029, changing the names of some persons who were earlier Lordship.
We are not understood. See, we are taking it in the most
Yes.
simplest of the form.
Yes.
Somebody makes an RTI, give me X document.
Yes.
Instead of giving the X document, some other document was given,
Yes.
and the court records that the other document is not available on record. Recording of the code may also be wrong, we don't know.
Yes.
You may have given the correct document also, we don't know.
Yes.
Why was this judicial order recorded? Because when suppose today I ask you for a document,
Yes.
either you give me the document or you say this document is not available.
Yeah.
You cannot give me a substituted document, either document B or C or whatever it is. Number one. Number two, even more so, you cannot give me a document which does not exist in record. That is a fraud.
That is not.
That is a serious
Yes.
fraud, Mr. Chisti.
But in director, look at that particular, that.
We
minus-
don't know.
That first minute is in record, Lordship. That was the first minute that was given in.
No, no. First, tell us why this order was recorded by the court.
Because-
Give me back my file. Why did the court record this order? If the, just a minute, if the court had wrongly recorded, you file an application for recall of that order.
That's
As long as a judicial order remains,
Yes, sir.
that a non-existent record in the document in the record was given under RTI,
Yes.
it's a serious issue.
No, let the SPR explain, Lordship.
We don't want explanation. Did you firstly tell us which document was given? Which document was given, Mr. Sheikh?
Lordship would be pleased to. see
Which
page-
document was given?
Page 27.
Page 27 document was given. Okay. Yeah, and this page 27 annexure 6 was given to the petitioner under RTI.
Yes, my lord, this bears the signature and
I don't know, Mr. Sheikh.
RTI, no, my lord, RTI application, RTI to me, same document given.
Yeah,
But
this-
7 and
this one is
8
given.
were wrong document given.
This one is given, Lordship. This is the.
Mr. Chisti and Mr. Sheikh, frankly speaking, I have not understood anything what you are trying to say, both of you.
Actually, my lord, problem is like this.
See,
Your lordship,
Mr. No problem. Problem is, one judicial order has been recorded. We are trying to find the correctness of it.
but that is the director given a document which is not on record. That is the thing.
Again, you are back to.
Yes, because my lord, original.
Mr. Sheikh, first you show me the document which was given to the petitioner under the RTI, which is not on record. First, you show me that document.
Yes, my lord. Your lordship in that case.
I mean, I think.
Because if it is right, this is a very something of matter of concern which should be
And the
taken
RTI
seriously. And if it is not right, we'll examine why the court had recorded it. Because court does not record anything without anybody submitting it. Show me the document which was given to the petitioner under RTI and not available on record.
These
It is not to be, it has been furnished to respondent 7 and 8. Who appears for 7 and 8? No point in asking the petitioner. Who appears for respondent 7 and 8? Mondal, where is Mr. Mondal gone? Just call Mr. Mondal. See, line is how RTI, a different document presently stated to be not available in the record, had been furnished to 7 and 8.
Yeah.
So we want to see which document was furnished to 7 and 8, number one.
Yeah.
Secondly, that it was furnished under RTI. Thirdly, that it is not available in record. It has nothing to do with the petitioner.
7 and 8, that is located in annexure 2 that I have given the plans that was submitted in the RTI report. Lordship. Annexure.
No, then why did Mr. Mondal make this submission to be recorded by the court? That it is not available on record?
Annexure 3, Lordship.
Hmm.
That is the RTI reply that submitted by the office of the director.
But if
Lordship.
Mr. Mondal doesn't come forward, what do we do here? He has to show to the court.
He has to-
Mondal nai niki, MU Mondal?
I have not seen him, Lordship.
If he does not come, we impose a heavy cost on this respondent number 7 and 8 for making a false statement.
Yes.
We'll take up after some time. Confer whether Mr. Mondal is available. If he is not available to respond to this serious allegation, because we have called the officers, he has to respond now. If he does not respond, we'll impose a cost. Mr. Chisti, we want to find out which document was given to this respondent number 7 and 8.
That is the first proposal.
I don't know.
Yes.
He has to point out.
Yes, Lord.
Yes, Mr. Mondal, please come forward. Your senior is behind you. On 12/5/2023, please take out that order. Read paragraph 8.
RTA reply, my lord.
I don't know. Read paragraph 8 over the order dated 12/5. Mr. Chisti, point out that relevant line to Mr. Mondal.
Yes. The RTA reply was given by. the
No.
matter.
Which document was given to the respondent number 7 and 8 under the RTI,
Yes. my lord.
which according to the respondent is not available on record? Please point out that document.
Yes, my lord, we have filed additional affidavit.
We don't know. Please refer to the page number.
Additional affidavit, my lord, page 6.
Page, no, running page number.
But-
You have to state the running page number.
Yes, running page, my lord, 5. RTA 5. Then, my lord, page 6.
This is the running test.
But I am hand over the blood. That is the running pen, but page 5.
I cannot be running.
Mr. Nair,
I cannot
Mr. Nair, can you explain what is a running page number?
running test.
Additional evidence.
No. I cannot.
It has filed earlier, my lord. Nowadays, my lord, running page, my lord, continue from the date.
Even then it could be after a repetition number, last and extra loss.
No, my brief is having the running page number. Find out. And instead of wasting time of the court at the expense of other learned counsel, please prepare yourself when we appear before the court.
File on 11/8/2022. No, I'm handing over my copy, my lord.
Why should I take your copy? You don't prepare yourself and you say, take my copy.
Page 73, my lord.
Please hand over.
73, yes. 70.
See, the court's time is a collective time of every counsel for every matter.
I'm extremely sorry, my lord.
Unnecessary, if you waste 5 minutes, 5 minutes of somebody else has been consumed.
Page 7.
This document, according to you, is not available on record.
This was furnished by the my lord.
Okay, the next page is not available on record.
Yes.
Hmm?
Then 74. 75,
74 and 75 are not available on record.
78 also.
78,
Then my lord 79.
74, 75, 78. There is no 78. 78 is some. This is
SLC recommendation.
77 or 79 or where is 78? দুখন লাগি আছে, sorry, লাগি আছে। 78. So 74, 75, 78 are not available on record.
There, but we have.
I don't know. When the court recorded 7 and 8 were given documents not available on record, it is your submission. We are asking you which are the documents given to the respondent 7 but not available on record.
The my lord, DLC.
Otherwise, we are going to impose cost on you
Yes,
for
right.
making false statement.
My lord, DLC recommendation and SLC recommendation.
Page number.
Yes. Page my lord, start from my lord, 73.
All these documents are not available on record. Produce the records to show whether these documents are there or not in the record. Not a photocopy from here and there,
Original record.
records. Because the allegation is under the RTI, documents not available on record was furnished to the petitioner, to the respondent. And the court had recorded that finding. And according to us, it's a serious aberration. The whole purpose of RTI will be frustrated if officials are allowed to furnish document which is not available on record. So to decide this issue, we want the records to be produced and that the records contain this page number 74, 75 up to page 78. If it is there, we'll ask the petitioner why you made a false statement before the court. If it is not there, we are going to ask you why you have given a document not available on record.
The record is, I will produce it, Lord, then. At 2000.
We call the officers for this purpose. They ought to have brought the record. The order where we require their presence is very clear. To explain the circumstance where it is recorded that RTI a document was given which does not find place in the record. So they should have been ready with the record. And tell the officers the record should not be manipulated and record must be actually the original record.
My lord, why does it file enter? Yeah, immediately.
আমি কি ফাইল আনছে নাজানো আপনার এগেইনস্টে এলিগেশন হৈছে যে ৰেকৰ্ডত নথকা ডকুমেন্ট আপুনি আৰটিআই দিছে হেতুৰ সত্যতাটো চাবৰ কাৰণে আমাক ৰেকৰ্ডটো লাগে যিটো ৰেকৰ্ডৰ পৰা আপুনি হেখন ডকুমেন্ট দিছে যদি ৰেকৰ্ডত নাই ইটস এ সিৰিয়াস অফেন্স যদি ৰেকৰ্ডত আছে পিটিশনৰ খুদিম ৰেসপন্ডেন্টৰ খুদিম কিয় ক'লে মিছা কথা এটা
মই যেতিয়া আমি অৰিজিনাল ফাইলটো আনি produce কৰিব পাৰিম।
ফাইল আনিব কিয় সময় লাগে ফাইলটো অফিচত থাকে আনিবহে লাগে নে ফাইল বনাব লাগিব
2000 মানে 17 চনৰ প্ৰভিন্সিয়েলাইজেশ্যন 21 চনত যেতিয়া হৈছিল
নাই, নাই।
ইউজ এটা ল
এইটো অৰ্ডাৰ 4 তাৰিখে দিয়া হৈছে এসপ্তাহ আগতে এসপ্তাহ সময় আছিল আপোনাৰ আনিবৰ কাৰণে আজিতো এটা নতুনকে কোৱা কথা নহয় ৰেকৰ্ড লৈ আহক ৰেকৰ্ড যদি নাই আপোনাৰ এগেইনষ্টে প্ৰচিড কৰা হ'ব আৰু ৰেকৰ্ড যদি আছে তেওঁ সোধা হ'ব কিয় মিছা কথা কৈছে কোৰ্টত
at two lot.
when there is no
Yes.
anything in between
Yes, yes.
either he is wrong or the respondent is wrong
Anyhow, 2000
লৈ আহক ৰেকৰ্ড শুনিম আজি আৰু বেলেগ কিবা লৈ নাহিব কিন্তু দেই ৰেকৰ্ডৰ নামত আৰু একদম সঁচা কথা ক'ব your case will hear you on merit later on. Yes, next slide. No, today we'll take up this RTI issue. We'll, for a merit hearing or the writ petition, we'll hear you on another day. Another day. But two will take up the RTI issue.
Item 1 for motion.
Yes, madam, what is this?
My lord, this matter relates to compulsory appointment, my lord. The petitioner's father died on 8/1/2007.
Was it placed before DLC?
No, my lord.
Not placed.
At that time, the petitioner was minor and after attaining maturity-
Khadim to Maridu. Mr. Saike, that Khadim order.
Respondent will go. Item 2.
But give a date of your application, date of death and everything, please. Yes. That one. That issue regarding that it don't have jurisdiction rejected, now on merit against the suspension order. Any other ground you have on the suspension order?
Suppose, my lord, suppose he's the authority, my lord, who has issued a suspension
Now,
order.
now what is your case?
Six provisional rule, six provisional, my lord. He has to inform the higher authority, my lord. If he is an authority, my lord, below them, he done.
What is the date of suspension, page number?
My lord, G7/2000.
3723. Have you filed a charge memo?
My lord,
It is a pending disciplinary proceeding.
my lord, no, my lord.
Have you initiated the thing? Have you conducted review?
My lord, I have no interest. My lord, is the motion, the first is it is coming, my lord. So that we are.
Some matters we have to take up at motion only.
My lord, but our names are not today also, my lord. We are in, my lord, division bench, that matter is going on, just now it is open, my lord. And division bench, my lord, wants that all the matters regarding when the person, the verbally ordered, my lord. Order has not yet come. That there are two parts, my lord. One part is the council has no power to like that way, and in some.
That we have already decided.
My lord.
We don't have to go
My lord,
anywhere else.
Then, my lord, there is a, my lord, in person to that, my lord, there is.
Now we'll examine the,
Well, whether we can initiate a departmental proceeding, that notification was issued by the government, my lord.
no, we are not on that
Well,
also.
we have the power, my lord, so that borrowing.
We have
borrowing-
accepted it, Mr.
My lord,
Chutia. We have accepted your power. Now we want the record as per para 21 of Ajay Chaudhary.
My lord, my lord.
Whether you have issued charge memo and whether you have conducted review or not.
Within 3 months.
Because this is a order of suspension.
My lord,
Produce that.
my lord,
If it is not produced, it has to go, this
my lord,
suspension.
my lord, my lord.
We are not on the issue of
Yes,
that
my
one. That is,
My lord.
we are quite convinced you have the power.
Regarding the factual part, my lord.
Regarding
whether
the-
that 3 months, my lord, it was reviewed or not.
Oh,
the
that
circuit was
one,
issued
that
or
one we
not,
are
my
going to,
lord.
not the other one. Other one you have.
My lord,
This,
can it be 2 more?
we have already passed the order.
My lord. Then,
That preliminary issue, we have already finally decided that you have the power.
my lord. But the other points, my lord, it's.
Uh-huh.
I'll take the instruction.
We produce that.
Well.
We,
Monday.
Monday,
Monday, I'll pick you, my lord, Tuesday.
Tuesday is too near. Let it be Monday.
Monday, I'm not here. Personally.
Today is what day?
Today is a Thursday.
We'll list it tomorrow.
Tomorrow, my lord.
Get the
I'll
info,
take it.
only you have to,
Instruction, I can take it on what phone, my lord. Instruction, I can take it over.
that is good enough for us.
My lord. Then, my lord, at
The
2, my lord.
statement of Mr.
At 2, my lord.
Chutia
At 2, my lord.
has more value for us than anything else.
At 2, my lord, at 2.
At two, okay.
My lord.
If it is not there,
My lord, my
some interim order is required.
My lord.
If it is there, we'll take
lord.
note of it.
My lord.
Item 4.
Yes, Mr. Nath,
My transfer at page 64 is under challenge.
to produce the entire records leading to the, where are the records?
Yes, ma'am. Yes.
Where is the order dated 15/9, Mr. Nath?
Page 64.
64.
As per record, my lord. Criminal case has been registered against her and He has been already suspended. So, of course, there's been.
On the basis of public allegation and outcome of hearing again, allowed to work as petitioner is Onima.
Our contention is prima facie, my lord, is punitive. It is issued in lieu of punishment. And even this complaint was not.
Mr. Nath, difficulty, the law is little gray both ways. Yes, how do you justify this order?
Which one, my lord?
How do you justify this impugn order? Hmm.
My lord, I have-
We understand we have flag marked 2 pages. There are very serious allegations against this person.
Yes.
But how this order is justified? If the DDO. Have you read the report?
No, my lord.
You
the-
have not
I
read.
just received just received, report, my lord.
Then why did you produce before the court if you have not read it?
That my lord is directed by the Sonam.
See, the departmental council is not supposed to be a post office.
Yes.
Just from one side, somebody will give and you hand it over. You should also apply your mind.
Yes.
Then make your submission. Read that those 2 flags, those 2 pages. Based on this material, how do you justify the page 64 order? Page 64 of the writ petition, not over your report. Mhm.
My lord, public allegation is that case has been.
Understand, how do you justify this order of transfer?
There, after my lord, some development has been. Brought up.
What development?
So cost has been issued against her and she has misbehaved senior official my lord, and she has been placed under suspension.
Where is that order? It's there in that same bunch.
Yes, it's there. I have placed-
Which one? Page number? Find out the page number of that bunch.
annexed is- You.
Q.
You.
What is this annexure Q? What is annexure Q? And where is the order of suspension?
I mean, I have to. I have to-
No, you have flag marked every page. Which one?
It's, green.
Uh, Show us the This is a show cause notice according to you. Q is a show cause notice. What is annexure Q? No, read that. Show cause notice. Show cause notice, what kind of a show cause notice? Hmm. Who had issued it?
District elementary.
What kind of a show cause notice is that? Is it a show cause notice under Rule 9 of the Disciplinary Appeal Rule 64, or it is some other kind of a show cause notice? What do we understand by annexure Q, that annexure Q?
Some allegation.
Sorry,
Some allegation.
allegation is a different word. What kind of a show cause notice is that? Because show cause notices can be of different types. What type of a show cause notice is that? Show cause notice can be a casual show cause notice. Show cause notice can be a formal show cause notice. It can be a under Rule 9, a discipline rule. What kind of a show cause notice is that? Yes, Mr. Chief, please try to read that document and tell us. Because accordingly, we have to pass our orders. No, what kind of a show cause notice is that?
Yes.
No, because show cause notices can be of different type, different grades, different
Yes, sir.
purpose.
Yes.
One can be a casual show cause notice. Yeah, why have you done that? Another may be you intend to drop some preliminary inquiry, show cause notice. Tell me what you have to do. It can be a formal show cause notice for initiating a disciplinary proceeding. So by reading that language, we are unable to understand what kind of a show cause notice is that. If you say it's a Rule 9 notice, we'll pass our orders in a different way.
Yeah.
If you say it is a casual notice, again, we'll pass it in a different way. But before that, we have to understand.
I think it is issued in a casual manner.
Hmm.
In a casual manner.
So now we like the district elementary education officer to respond. Why is he behaving in so casual a manner? You come to page 64 of the writ petition.
Yes. On the basis of the public allegations and outcome of hearing against Anima Devnath, 80, and insert test teacher. So and so Goripur girls they have allowed to work at 552 number or Dumordaha JB school as 80, and Srimati Bonali Devnath, 80, 552 number Dumordaha JB school is hereby allowed to work as 1475 number Goripur girls LP school as 80.
Can you do that on a public allegation?
No.
No. So this order should not be maintainable in the present form. Now you read the two green tags that we have put in that record produced before the court.
One is that so-called green flag.
No, three green tags are there. Read the other two. Green tags put by the court.
Yes, yes. It's a letter from the sub-inspector of school to the deputy inspector of school. Submission of inquiry report. With reference to the subject cited above, I have visited 1475 number Goripur Girls LP School along with the deputy inspector of school on the basis of complaint against the insert's head teacher, namely Srimati Anima Devnath, by the teaching staff and cook cum helper of the said school. Teaching staff are not satisfied with the behavior of insert's ST of the said school in all respect, administration and day-to-day manner. According to teaching staff reported that IC head teacher is not doing any classroom transaction. If anyone.
No, till that extent, we have no difficulty.
Yes.
It is for you how you deal with your teachers.
Yes.
Somebody takes class, doesn't take class, it is your problem.
Yes.
Read after that.
On 9/6/2023, an incident was happened by the insert's ST Anima Devnath with the cook cum helpers of the state school. It was happened for a matter of lock and key of the kitchen room. CCH were asking for lock, but the insert's ST madam was busy on mobile phone at that time. Husband of madam was arrived in the couch field, and he was talking to the CCH and wrongly said that you should punish by the handle of two.
So now this is where we are little concerned.
Yes.
Is the cook
Yes,
a man of a little below a human being?
Yes.
That the husband of the headmaster will threaten him with sandal and everything? Why? Because he's a cook. He is not a very human being of very high stature. And happened in the presence of the headmaster. Head teacher could have prevented that situation.
Yes.
Ask the husband, please don't do this thing in my school. What is this conduct? And read the next one.
yes. So, this is also from the sub-inspector of school to the DO Dhubri. Subject life threatened by HT Anima Devnath of Soncho School. With reference to the subject cited above, that HT Anima Devnath was calling me by mobile phone on 8/9/2023 at 8 PM approximately. She strictly asked me and threatened me. You were submitted a bad report against me. If that report basis any action, if that report basis any action will be taken against me, then I will see you and could not let you easily. I replied her that I have submitted
So this is a
the
threat.
threatening, yes, threat.
Threatening to hit the cook or hitting the
Yes,
cook with sandal
Yes.
and threatening the inquiry officer.
Sir,
What
yes.
does it amount to? Acceptable conduct
No,
out of a headmaster?
no,
No.
this serious misconduct.
Then what should be done?
It should have been immediately suspended.
Then, but what has been done? What should have been done and what has been done? So therefore, we put the question, why the DO is so casual?
Ultimately, she was suspended by order dated 5/10/2023, Lordship.
Where is that order?
This is the subject to the approval of Director of Elementary Education, Assam, Srimati Onima Devnath,
Which annexure that you?
Annexes U.
Huh.
Is hereby placed under suspension with immediate effect for non-execution of higher authority order, misbehave with higher authority teachers, and also trying to destroy school documents such as attendance register, students admission register, counterfolio of school certificate, and non-handling
Suspension under what, which provision?
that
Hmm. That's why we asked you. We are not clear about the you because what material has been produced, what has been argued by Mr. Nath, this order requires an interference. But moment we interfere, because of your casual approach, we are a little hesitant to interfere because moment we interfere with this,
Yes, sir.
you'll forget about everything. Back to normal again. But had it been a formal show cause notice, then we would have left you to arrive at your own decision. They'll give the reply, they'll give the thing, whatever action you want to take.
Yes.
They are entitled to a reply also.
Yes, sir.
They are entitled to a reply. These allegations may be right, it may be wrong, no one knows. But there has to be a definite procedure of law to be followed.
Yes.
So is the elementary education officer not very casual in the entire approach? Hmm? So now let him show cause. Why he is so casual? What else to do?
Otherwise, she is an SES officer, she is in charge of DO.
What to
Same is
do?
the-
ACS
and
doesn't
we are-
give you the indulgence to be casual in your work. We'll take up today itself. Because this order we feel is not maintainable in the present form. It has to go. This order they have challenged. But difficulty is the circumstances.
Let them, madam, if they are contemplating a departmental proceeding, madam, let them proceed with that.
That's why we are
But
saying,
transfer is different, madam. We are on the transfer. Let's
Mr.
transfer
Nath,
both.
that's precisely what we expressed just now.
Yes.
Yes.
Yes, that can be done.
Take up at 2 o'clock, you confer with the DO, what is going on, and ask the DO to explain what is this annexure Q. What the DO means by that.
Yes.
And you also inform the DO about the relevant provisions of law
Yes.
under which they have to act upon. We'll pass our order.
Yes.
2 o'clock, we'll
Yes.
take up again. Huh? Let him come back with this information.
Item 5,
Just made a Burgoyne, T9 refers to it. Which order is challenged, Madam Burgoyne?
Lordship at page 59.
59. What is your ground of challenge? Tapan Sharma, Kumar Sharma is not a professor.
No, he does not belong to the BEd service, the Assam State Council of Education, Research and Training.
Okay,
He
it's a
belongs
particular
to-
service.
Yes, he belongs to the Diet service.
Okay.
And the fact that he belongs to the Diet service, we have enclosed a document. He is a senior lecturer of Diet. And in the latest gradation list which is published, his name is there.
But he has been posted, he's working like that.
No, Lordship.
No, no.
Lordship will see next page, Lordship.
Hmm.
These are pay slips, Lordship, since 2017, he is getting
Yes.
salary.
So if Tapan Kumar Sharma is not entitled to be a professor in the CTE,
Lordship.
but he's wrongly made, you have to challenge his,
I'm
but as long he is there, he's also, once he had entered this service, rightly or wrongly, he is entitled to be the principal also. But if his entry is wrong, you challenge that.
Next
Lordship,
document,
may I
Lordship will see one
may I
gradation
submit,
list.
Lordship?
Hmm.
He was brought in here in the year 2017. Thereafter, Lordship, in the year 2019, when the post of principal fell vacant, after superannuation of the then incumbent principal, he was made the IC principal of the college. And the BEd Teachers Association, as well as the present petitioner, they filed objection again before the authorities, and then he was removed. The additional.
But that cannot be a
no,
precedent.
Lordship, my submission is.
You may submit, no
Yes,
difficulty.
after that,
but
we challenged that his appointment before the Honorable High Court.
You had challenged it,
Yes,
the
yes.
17.
Yes.
What happened to that?
And in the meantime, the regular principal was appointed. So,
No, what happened to that challenge?
yes, that is why, Lordship, the matter became infructuous as it is. Lordship.
Infructuous.
The regular principal from the BEd service was appointed.
This matter can never
We have
become,
chal-
Madam Borgohain, that's where you went wrong.
Yes, Lordship will kindly.
Merely
tell us-
because regular principal is in, the illegal bringing in of Tapan Sharma to this service, that cause of action will remain. It will never become infructuous.
Lordship,
You should have got it decided.
No, he was not brought into the service because his name is nowhere reflected in the professor's
Doesn't matter.
He was not brought into the
It
service.
is reflected, Lordship, you
No, no,
kindly see the
Lordship.
second dance, Lordship.
Lordship, a person's name cannot be in both services. Lordship will kindly peruse the gradation list of. that
Madam
service.
Borgohain, that's why the remedy before you is to challenge this order dated 29/8/2017. If this Tapan Sharma is not entitled to be a professor in CTE because he belongs to another service, we'll definitely look into it. But once this man is already inside, how can you say that he will not be entitled to be
Lordship,
principal?
He was not brought into the service. That is what I am submitting. Lordship,
Madam
kindly-
Borgohain,
Yes.
every lawyer who enters this court is entitled to argue before the court if the matter is there. Okay. If your argument is that X is not a lawyer, he is a fraudster, then you have to challenge his being not a lawyer. You cannot say, don't allow him to come to the court.
Lordship, we have filed an
We are trying to be fair with you. It's up to you.
Yes.
You can
Lordship,
argue.
we have filed an affidavit enclosing the affidavit in opposition, which had been filed by the then commissioner and director in the earlier round of litigation. And then,
Madam Borgohain,
may I just complete?
you may complete, may not complete, we are not concerned, but we are bound to point out to you, even if I accept this, what you are submitting, it will lead to a conclusion that this order dated 29/8/2017 is bad in law. It could not have been done.
Lordship, may I submit? He was not, why I'm submitting that he was not brought into the service. The commissioner's affidavit in that petition says so. He is a member of the Diet service and he was appointed as a IC principal because there was no professor at that point of time. That is what the commissioner's affidavit say. That was filed in January 2022, and we have enclosed that in the affidavit which we have. Lordship will kindly take up the affidavit which we have filed, enclosing those documents.
Page number.
Page number 82, serial page number 82 of that additional affidavit which we have filed. The affidavit in opposition filed with the Commissioner and Secretary to Government of Assam Education Elementary Department. If your Lordship peruses paragraph 4.
List along with the WBC 1949/2020. It's a affidavit in some other matter. We have to list that writ petition.
Yes, therein we had challenged his appointment as IC principal. And therein the commissioner says that he is a
Very good.
member of the diet service.
To rely on the affidavit in
yes.
another writ petition,
Yes,
we'll
that
list
may
it
be
along
called,
with that.
that may be called.
Lordship, may kindly also one the document, Lordship, once, the second document was.
You want to, that document to be called for?
No, that is already there, Lordship, one second.
No, we'll
document.
take note.
Lordship, Gedison list is there. Wherein
No,
the
no.
name-
We'll hear you on the next day on all this. Because today we are only calling the other records of the other writ petition, because the pleading in that writ petition is relied upon to establish some legal right.
Yes.
We'll look into it, how to proceed. But Madam Burghai, nowadays when we try to give some good suggestion, people do not have the habit of accepting it.
Lordship, that is why we have not challenged.
Very
because
well,
the
you
commissioner
continue. We'll hear
himself
you.
says-
No difficulty.
Himself says,
We'll hear you for days together. No
Monday,
difficulty. Yes.
Monday, not.
Monday, yes. Get a Monday party.
Okay.
Take whichever is convenient. Date is available. Hmm. Kali. No, Monday, what do you say? Fine. Monday? Mhm.
This matter relates to your lordship cancellation of the admission in MPBS.
Cancellation.
The
of-
last occasion your lordship has directed, and by this order, that I should produce some documents or information with regards to your lordship the petitioners. Forefathers were their garden laborers. I've got some documents, your lordship, which clearly indicates that the grandfather as well as grandmother were working. And
Which document?
no, that is not there. Your lordship is direct
Some medical admission or what?
medical. This was on the basis of your lordship tea garden labor quota. And your lordship in the order dated 9/10/23 directed that
Manager,
father, grandfather, grandmother, all were there.
which Kuldeep what Das? What's her name? Kuldeep Das.
Kuldeep Tasa.
Tasa, sorry.
Wanted that earlier his forefathers were there. There are many documents. Even the thesis clarification was also issued by the tea garden that their grandfather, grandmother were.
These documents were not taken note of by the committee.
The committee, we appeared, your lordship.
Did you produce these documents before the committee?
Yes, we have produced.
These were produced?
Yes, we have.
Uh,
At that initial point of time,
No, no.
we are not annexed.
The documents that you have produced
Yes.
now, did you produce this before the committee? What did the committee say?
Scrutiny committee. There to reply the
Yes, Mr. RM Das, who appeared. Where is Mr. RM Das? Can you hear him?
Bora to Vidana.
Not present.
Like,
Sorry,
He is not present today.
not present. No, these documents give some kind of indication
Yes.
that some forefather worked in some tea garden. It's a
What-
factual
Yes.
assertion they are making. This has to be verified.
Yes, sir.
If verified and true, they belong to the tea garden community. And if it is not true, it does not belong.
in fact, one of the documents
Oh.
was annexed with regard to.
So we want to know whether the committee had taken note of these documents. And if yes, what view was formed? Why was it rejected? If it is rejected in an improper manner, we'll send it back to the committee that you relook on the entire aspect
But if sometime maybe given,
today.
not today, Lordship.
When will he come?
Lordship, he will be not available today, Lordship, tomorrow or day after, Monday, Lordship.
But he can't wait so long also.
Till Monday. Or tomorrow, Lordship.
Tomorrow,
Tomorrow I am there.
Monday,
Monday I shall not be there the next week.
then after the vacation.
If possible tomorrow, then otherwise.
Hmm. The respondents in the social justice department to produce the records of the state level scrutiny committee for examination of the court as to whether certain documents which had been produced by the learned counsel for the petitioner pertaining to Bipin Bagh tea estate that one forefather of the petitioner had worked as a tea garden laborer in that tea estate was duly taken note of by the committee or not, and what view the committee had formed on the in respect of such documents. List on whenever you want.
Item,
Mr. Gogoi, he has produced some documents saying that he belongs to a tea garden. We just want a record of the Social Justice Committee, whether they were taken note of. If they have not taken note of, because those documents say that some forefather was a laborer somewhere, Bipin Bagh tea estate. So they will send it back.
Yesterday, my lord, an order has been passed by the division bench on the same issue, where my lord that 99 order is under stilling, whereby lordship was directed for my lord going for an inquiry. Some order has been passed, but my lord, I have not got the copy. Honorable court has my lord just expressed that my lord find that a press inquiry will be conducted within a period of 3 months. Whoever has been admitted and some few more seats will be my lord.
No, this requires, and see,
Yes,
Mr.
that's why. They
Gogoi,
cannot-
whatever you say, division bench, single bench, it doesn't matter.
So my lord,
If
just-
people who do not belong to tea garden laborer is wrongly issued certificates and they assert the post reserved for tea garden laborer, it's a constitutional fraud.
my-
No constitutional fraud can be justified on the basis of any technicality of law. That's the bottom line. Whether it's division bench, single bench, it doesn't matter.
Since there will be an inquiry.
Only thing, if the inquiry was not done in a proper manner, will require the inquiry to be done.
Yes,
That's all. That's the bottom line.
My lord.
And constitutional fraud cannot be recognized in any other form.
In fact, in item
It has
7,
to be, because by going for the right of natural justice of one candidate, the right of a genuine candidate under the constitution is being violated.
my lord,
A constitutional court should not encourage constitutional fraud. But if there is a lacuna in the procedure adopted, that is totally a different aspect, because everybody has a right to espouse their own cause.
In fact, my lord, item number 7, which has been mentioned today, it has been adjourned, but in that case, my lord, the certificate reveals that my lord, the father of the my lord petitioner, he is a supplier in the.
So this is a fraud.
Despite that, he got the my lord certificate.
So this is a fraud.
Only in the inquiry it came to light. Now he has come up with the certificate. Certificate is very clear. He's a supplier, he's a
So
constructor.
don't you think this is a fraud? And should any court,
At least for this case.
should any court, whether division bench, single bench should encourage a fraud? I don't think so.
Only the inquiry.
Only aspect is, and this is what we are trying to do. Because the genuine people who are deprived also has a legal right under the constitution. And just because they may not be before the court doesn't mean you ignore their right. And I think every court should look at the point from that point of view, not otherwise. The issue of natural justice, etc., is a procedural requirement. If it is not done somewhere, correct it. Get it done. But that doesn't mean a constitutional fraud will be allowed to persist. So now also we say you, what we want to do now, go back to the committee. Go back to the committee, give him every opportunity to explain that he belongs to the tea garden laborer, arrive at a conclusion. And by going to the committee, the natural justice is inbuilt, it is served. This petitioner. Or they say manager could not furnish any official record. Committee may be right. Again, the certificate culture. And we have, one of our judgments, we have already expressed what is a certificate. Certificate is not one line written by one man.
The 99 order.
That will create a fact. Certificate shows the existence of a fact. That's all you have to prove. But in an enthusiasm of something constitutional wrong should not be allowed to prevail. We are aware what is going on. And if somebody feels that constitutional fraud should be allowed to prevail in the guise of natural justice, we don't know. We leave it to the Almighty, what is going on in this country. And natural justice, mind you, is not a straitjacket formula nowadays. 30 years back it was. Now, the core issue of whether you have a legal right, constitutional right, or you don't have, that's all. That has to be decided. And if somebody feels something more has to be looked into, it should be looked into, that's all. Give him the complete hearing, whatever he wants to say, and then arrive at your conclusion.
What I wanted to point out is already there is an order to division bench to conduct an inquiry again, madam, within a period of 3 months.
Do it.
So he can participate. That's what I want.
Yes, do it. You can go back.
Won't be decided.
Yes, you can go back to the, and in fact, that is what we wanted to pass also.
Yes. That's why I wanted to. So that order probably will cover the case of the petitioner.
In fact, we wanted to pass the same order when he says that these are the documents we're not giving adequate consideration. Let him go and prove his case.
We
That
want
order,
that.
madam, today I don't have it. So I
No,
can-
order we don't need. For law, you don't need orders.
It will be
Law, you have to understand the law, that's all.
That's the limit of law. Otherwise, madam, there will be an inquiry. And if they want to participate, they
Ah,
will.
yes, you can hold an inquiry. We have no difficulty with holding any number of inquiries. But
Genuine.
genuine should come, and more importantly, constitutional fraud should not be allowed to take place. Because it will be a travesty if you allow it. By any technicality of law, if you allow it, it will be a travesty. It's better you don't have these reservations then. If you allow people to manipulate and get into reservation, you better you don't have it. What do you do? But Mr. Das, you are there. We ask you straight away to go and appear before the committee. Heard Mr. Y.S. Madan, learned counsel for the petitioner, also heard Mr. P. Saikia, learned counsel for the Mr. Your name, please. C. Sharma for respondent number 1, being the welfare of plain tribes and backward caste department. No, authority, number 1, 2 authorities under that department. Mr. B. Gogoi for the authority on the medical education department. Director of T welfare, who appears? Mr. Saikia, you appear? Or you appear? Three and 6, B. Gogoi Divo, 4 and 5, being the authorities under the Director of T Tribes Welfare Assam and District Commissioner Dibrugarh, P. Saikia. The petitioner, who is a candidate for the first year MBBS course of the year 2023 in the state of Assam, is aggrieved and who offers the candidature as a candidate belonging to the TGL, ex-TGL category, is agreed by an admission notice dated is agreed by admission notices dated 28/9/2023 and 29/9/2023, by which a provisional selection list was revised. The petitioner was required to appear before the state level caste scrutiny committee under the Department of Welfare of Plain Tribes. Is it so? I think you were wrong. Social justice, I think. This is for scheduled caste and scheduled tribe. For OBC, there's another committee. What's the name of your committee? State level scrutiny under the Social Justice Department, pertaining to the claims regarding the other backward classes. On the question as to whether the petitioner do actually belong to the TGL or ex-TGL category. Reservation in favor of TGL, ex-TGL category is available at entry 24 of the notification dated so-and-so of the Government of India, providing for the list of OBC in the state of Assam, wherein to be included under entry 24, there is a requirement of a factual determination as to whether the petitioner or any of his forefathers was a laborer in any of the tea gardens in Assam at any period of time. The petitioner, on being subjected to the state level scrutiny committee, was rejected to be belonging to the TGL, ex-TGL category. And being aggrieved, this writ petition is instituted that without giving adequate opportunity of hearing to the petitioner, his claim to be belonging to the TGL, ex-TGL category had been rejected, and consequently the provisional select list, consequently name deleted from the provisional select list. Mr. Y.S. Mannan and counsel for the petitioner, while presenting the matter, had referred to certain certificates issued from the Bipin Bagh Tea Estate in the Dibrugarh district, wherein it is certified that who is the tea garden worker?
Yeah, one is the grandfather and one is the both.
Grandfather. What
Grandfather
are the
and
names? What are the names?
Names, your lordship. Modern,
That so and so being the grandfather of
grandfather is
the
Modern Tassa.
that Modern Tasa being the grandfather of the petitioner, and so being the grandmother of the petitioner, were both tea garden laborers in the Bipin Bagh Tea Estate. According to the petitioner, the contents of the certificate was not given a due consideration by the caste scrutiny, state caste level caste scrutiny committee. A prima facie reading of the certificates produced before the court shows that it is certified that the aforesaid two persons who are claimed to be the grandfather and grandmother of the petitioners were tea garden laborers in the Bipin Bagh Tea Estate. In view of the above, the matter is remanded back to the state for giving adequate opportunity of hearing to the petitioner to firstly establish that the aforesaid two persons, namely so and so, are respectively the grandfather and grandmother of the petitioner. And secondly, that the aforesaid two persons, namely so and so, were earlier worked as tea garden laborer in the Bipin Bagh tea estate, if necessary, by calling for the records of Bipin Bagh tea estate, so as to the so that a correct factual determination on the aspect can be made.
The name of the grandmother is Sulochana Prasad.
Huh.
Is there?
Yes, Mr. Gogoi, it's okay.
Notification is dated by 10/9/1993.
10/9/1993.
20.
The
Not 9. 23.
petitioner accordingly to appear before the committee on a date and time to be fixed by the committee, and the committee through the Director of Medical Education shall inform the petitioner about the date and time of for her appearance.
Lordship is disposing of the.
I think this is the only grievance you had. Why do you keep it pending?
No, no, I'm okay.
Uh,
Agreeable.
The legal rights of the petitioner to claim a seat in the first year MBBS course under the category TGL XTGL would be subject to the decision that the committee may render.
Yes.
CCL, my lord, is only 40.
I don't know. We're not keeping it open. You go by law.
No, in fact, my lord, that's why I want to point out, in fact, in the division bench, my lord, Honorable Court has already spelled out that, my lord, out of some 9 candidates were left out after the inquiry. They found to be not, my lord, within this particular category. So now, my lord,
No, for this, it will be determined as per law.
as per-
Do it.
because, my lord, Honorable Court has stated that, my lord, if not this year, my lord, next year also,
We don't know.
if it is found, then.
Then we let them decide on that person.
That will require another hearing, so we don't go into that question. Because there are two conflicting Supreme Court judgments.
No, my lord, here in 2020, my lord, new judgment has come up where it has been, Honorable Supreme Court has held that, my lord, this 30th September can be extended to, my lord, 30th, another 30 days, provided, my lord, some genuine issue is founded.
Then why don't you do it before 30 of that?
No, Honorable Division Bench stated that, my lord, it will have to be within 3 months as per.
No,
my lord,
no,
Madhurima Pandey.
Mr. Gogoi, what we are saying, if you do it as per the 30 days extended by the Supreme
So
Court.
that part, my lord, whatever vacancies there, my lord, that direction is already covered. 2 were available, and as per the Honorable Supreme Court order, 2 can be, my lord, further, my lord,
That's what we are saying. If the 30 September had been extended by another 30 days by the Supreme Court, you follow that and give him the relief this year itself.
So that's why, my lord, that there will be again a conflict, my lord, because there's some petitioner appellants are before the, my lord, division bench. They are also to be considered. So everybody will be considered, including the present petitioner.
No, no,
That order covers everybody.
no,
Who has
no,
been left out.
doesn't matter. If Supreme Court has given him a window of getting it this year itself, why that window should be closed?
That's why I'm saying, that order covers them,
Which order?
division bench order.
What does it say?
That's why. my lord,
30 days,
present-
you say 3 months.
So 3
and-
months for the investigation. Whoever has been left out after the, my lord, inquiry.
No, no,
Now-
instead of taking 3 months, why don't you still have, how many days you have?
Today is
Uh,
12th.
3 months is the time. my lord, given
Do
by the
whatever you
division
do. We are leaving it open as per law.
Much.
bench.
See, we make our best effort to help everybody. Rather than creating an obstacle, try to help the litigants. Whosoever is entitled should get it, whosoever is not entitled should not get it.
No,
That's
they
all.
will get, my lord, but we cannot, my lord, admit if, say, my lord, 8% are found to be genuine after the inquiry, it will be difficult. So, Honorable Court has stated, my lord,
Do whatever you
some-
do. It's up to
He
you.
may come in on merit, can't, if he is found.
Much.
Item 8 for admission.
Take up the after sometime, Lord. I didn't get Mr. Yukana is on report number 2, Lord.
Absolutely.
Item 11.
Who appears, Mr. Somewhat standing on the UGC states, who appears for the petitioner? Item number 1516.
Item 11.
Which matter may be timely taken up after some time.
After some time may extend to 1 month.
After vacation.
No, we don't mind after some time, but a period after some time, maybe after maybe 30 days also. Agreed, yes, after some time.
Item 15.
The way the matters are going, this after some time expression may meet 30 days also.
Maybe.
Yes,
But the impugn order, my lord, through which my.
Chief Account respondent prays for 1 week time to file affidavit.
That
File,
file,
Mr.
file,
Chief.
file, file, my lord.
File.
That file. Impugn order, my lord,
What is?
page 30, my lord,
Please.
33 original copy, whereby my B.Ed degree obtained from IGNOU has been declared invalid.
My lord, we have filed a affidavit yesterday only.
Is it on record?
Probably.
It's stated that an affidavit of the respondents had been filed, which is not on record, list along with the affidavit.
But fixed date, my lord, before vacation, because otherwise my application for submission for a headmaster will not be accepted. Because my degree, B.Ed degree itself has been declared not acceptable by the authority, but it is otherwise acceptable as per law, my lord.
What is the last date of that?
31,
headmaster?
31, my lord,
31 October.
October.
So, yes. Which is the impugn order?
Impugn order page 32, my lord,
32.
page 32, third paragraph. Type copy is there before that.
Do you have any type copy of this one?
Yes, Lord.
Not-
Page, before that,
33
my
is not
lord,
readable.
before that page
Hmm.
30, my lord, type. Paragraph 3.
Off-campus mode B.Ed degree is not acceptable. Not acceptable. Yes, then what is wrong with off-campus B.Ed degree?
My lord, they have
No,
not taken the permission.
NCT is the final authority on these B.Ed degrees.
Yes.
So if they say off-campus is acceptable, under which provision of law you will make it non-acceptable?
In our affidavit, it is contained that
Mhm.
he has not taken the permission for the B.Ed degree, and he has not fulfilled the criteria of 10 years, 10 years teaching experience.
No,
As
that is
against-
another factor.
Yes.
B.Ed degree and 10 years are two separate aspects. We'll deal with him separately. But under which provision of law a B.Ed degree which the NCT claims to be a valid degree will be rejected by the government of Assam? Yes, Mr. Mojumdar, you are interested to say something? No. We are going by Mr. Alam's statement that it is a valid degree as per the NCT. So now if NCT says a particular B.Ed degree is valid, Under which provision of law the education department will say will not accept it?
We cannot. That is.
No, he says, so therefore,
That is distance education, off campus and distance should be two different.
don't know. Why, where is your B.Ed degree?
My lord, page number 22,
20,
21 is the certificate.
21. Indira Gandhi National Open University. Very well. Open University itself shows it is distance.
Page 23 is the recognition by the entity.
Mhm. Grants recognition to Indira Gandhi National Open University for B.Ed.
Another department, if it is from the IGNOU, Guwahati University, I don't. But this will require, I have to get a consultation of the department, and now they have decided to accept the B.Ed degrees from the IGNOU and the IDOL, I remember a notification. Lordship has it after some,
This appears to be IGNOU only.
IGNOU, if it is IGNOU, then it is distance education, it is off campus.
Whatever it is. So by this order,
Order says it is off campus.
so it is wrong.
Off campus perhaps will not be correct because IGNOU gives it on a distance. mode.
Understand. So you verify his qualification as per the qualification.
Yes, it can be.
In one stroke, if you write that it is off campus, it may not be correct. So you set aside, set it back. Take a call on the degree. In doing so, you take note of that NCET order dated 28/5/1999. I think this is the same one he has produced. Huh?
Yes. And we also have to take note of the fact that B.Ed degrees by IGNOU and IDOL in distance mode are now being.
What is IDOL?
The Guwahati University, the.
No, I don't know. He got it from IGNOU.
IGNOU, yes. ma'am.
Number one. NCT says IGNOU degree is accepted in law. So how other authorities can say that we don't accept it?
At the point of time when this order was issued, the impugned order, at that point of time, the department, I think, within the department, the notification accepting the IGNOU.
So that is an order passed without appropriate material. So it has to go. Heard
No,
Mr.
that
B.
was not in
Prakash.
existence. The notification was not in existence, therefore this order. Thereafter the
No,
notification.
it was in
But
existence.
So this one, yes, that is.
Your officer did not
yeah.
take note of that,
Yes.
not that it was not in existence. Heard B. Puradan counsel for the petition also.
It's probably again.
Any private respondent? Yes, what do you say? Mr. Ali. Your client is an incidental beneficiary of an order against him. You are not a necessary party in this case. So we did not hear you on his degree. You are only an incidental beneficiary because an illegality had been done to the petitioner, therefore you come in. So how can you justify that the illegality done is not an illegality? You have no locus to submit that. 60 something. An incidental beneficiary is not a necessary party. Supreme Court has laid down that law. We'll come back. Pass the order. You can say whatever you have to say, but you cannot say anything against his degree. That is between the department and the petitioner. We'll come back and hear you. What did you want to say? That his degree is bad.
Only part experience.
But that is a different. Mr. Ali, here he was not rejected because he did not have experience. Here rejected for not accepting his. We'll send it back. Heard Mr. B for request. I alarm for the NCT, H Ali for respondent number 5. The petitioner Om Prakash Chaturvedi is stated to be the only teacher in the Swadhin Bazar High School in the Kachar district who has the qualification of a B.Ed degree. Upon the death of the earlier headmaster Joinal Abedin Borguia, the inspector of schools Silchar Kachar was allowed to act as the in-charge headmaster of the school, along with financial powers, as per an order dated 26/8/2020 of the director. Must be a director, huh? Mr. Majumdar. Inspector allowed means he has to be director. He himself cannot take
Inspector
charge.
was allowed by the director.
By of the director.
Page 29.
The president of the SMDC of the school submitted a representation dated 9/2/2021, which was signed by the other members of the SMDC before the commissioned secretary to the government of Assam in the secondary education department, that the respondent number 5, Fakhrul Islam Majumdar, who is otherwise the senior most teacher in the school, be allowed to be the in-charge headmaster. Consequent thereof, the order dated 26/2/2021 has been passed by the director in charge secondary education Assam. Sorry. Upon considering the representation of the president and others of the SMDC, the director, upon scrutiny of the list of teachers of Swadhin Bazar High School, found that there was only one teacher having the B.Ed degree, that is the writ petitioner Om Prakash Chaturvedi. But the director was also of the view that the B.Ed degree was obtained by Om Prakash Chaturvedi through an off-campus mode, and accordingly, it was found unacceptable for the director. Accordingly, the degree itself was found unacceptable for the director. In the circumstance, the director was of the view that there was no teacher in the school who had a valid B.Ed degree. In the circumstance, the respondent number 5, Fakhrul Islam Majumdar, who was otherwise the senior most teacher, senior most of the teachers amongst the teachers not having B.Ed degree in the school, was allowed to be the in-charge headmaster. The order dated 26/6/2021 is assailed in this writ petition. A little minor variation doesn't matter. It will be irrelevant. Ultimately, he was allowed.
He was allowed, but he doesn't have B.Ed, so he should not have been allowed. That is what I was
That's why.
asking. He could not have been.
No, his reasoning is no one is there, so give him. Anyway, whatever it is. Mr. B. Purokayastha, Learned Counsel for the petitioner, refers to his B.Ed certificate available as Annexure 2C, page 21 to the writ petition, which is a certificate issued by the Indira Gandhi National Open University (IGNOU), wherein it is certified that Om Prakash Chaturvedi had been awarded the degree of Bachelor of Education. And that education, and June 2015 is stated to be a date. Mr. B. Purokayastha and counter petitioner also relies upon an order dated 28/5/1999 of the Regional Director of the National Council for Teacher Education (NCTE), which is the statutory body governing the award, governing the B.Ed course, that the Northern Regional Committee of the NCTE had granted recognition to the Indira Gandhi National Open University for awarding B.Ed degrees in a 2-year course from the academic year 1999-2000 . Mr. I. Alam, Learned Counsel for the NCT, also supports the state order dated 28/5/1999 and submits that a B.Ed degree obtained from the IGNOU is otherwise a valid B.Ed degree under the law. As the name suggests, a B.Ed degree from IGNOU is a degree obtained from an open university. But when we next para line two. But when we examine the order date, impugn order dated 26/2/2021, the B.Ed degree of the petitioner Om Prakash Chaturvedi was rejected by the director by accepting it to be a degree obtained through off-campus mode. It is clarified by Mr. R. Mojumdar, Learned Counsel for the Education Department, as well as Mr. I. Alam, Learned Counsel for the NCTE, that a B.Ed degree from an open university and B.Ed degree through an off-campus mode are two different concepts, and where two separate laws govern the two aspects. In view of the above, we have to accept that the Director of Secondary Education, Assam in charge, in the order dated 26/2/2022, was fundamentally incorrect. Firstly, in its conclusion that the B.Ed degree of the petitioner from the IGNOU was a degree through off-campus mode, and secondly, that the said degree is not a valid and acceptable degree in law. Accordingly, the order, Mr. H. Ali, Learned Counsel for the petitioner, on the other hand, raises certain objection that even otherwise, the writ petitioner is not entitled to be the in-charge headmaster, considering his length of service. But the said submission has no relevance in the issue before the court in the present writ petition, inasmuch as the question of acceptability of the B.Ed degree of the petitioner from IGNOU is an issue at hand in the present writ petition. Full stop. Accordingly, the order dated 26/2/2021 is set aside and the matter remanded back to the director to take a to pass a fresh decision as to who should be the in charge headmaster of the Sadin Bazar High School. In doing so, the headmaster to the director to also take note that under the law as laid down by this court in Jagannath Pegu versus so-and-so reported in so-and-so, to be an in charge headmaster, the incumbent concerned should have the necessary qualification of a regular headmaster. And further, that under rule 14, is it 14? One of the rules of 2018, 12 over 8018.
Sorry, 14.
14 of the rules of 2018. Pura naam nidiba. The required qualification for a headmaster is a degree, is also includes a degree of B.Ed. Meaning thereby that an incumbent who would not have a B.Ed degree may not be entitled for being promoted either as the headmaster or being allowed to be the in charge headmaster. Accordingly, the matters stands remanded back to the director for passing a fresh order as to who should be the in charge headmaster of the school by taking note of the relevant law applicable for appointment of a headmaster. And also taking note of the B.Ed degree of the petitioner, which is found to be a valid degree under the law. The reasoned order to be passed within 1 month from the date of receipt of a certified copy of the order. This one. I alone has also produced certain order. They also produced the order dated 28/5/1999 of the regional director of the Northern Regional Committee of NCET, as well as a communication dated 9/8/2007 of the member secretary of the National Council for Teacher Education, which also makes it discernible that the B.Ed degree offered by IGNOU is a valid and acceptable degree in law. The communication dated are kept on record. Thank you.
Where Lordship has put it, rule 14. Rule 14 with the graduation and the B.Ed degree, madam, Lordship like to add other eligibility conditions.
For B.Ed degree, we said that.
That is, rule 14 also has other eligibility conditions.
No, therefore, in the end, I said, but
The other eligibility conditions for appointing him also should be similar. Our affidavit says he doesn't
no,
have 10 years of experience.
the director can take note of that. We never said. That's why in the end I said by taking note of all the relevant positions. Last line to kill is,
All the
I think it's there. It's already there. But I need not spell it out.
he may not spell out other relevant provisions.
Last what's person.
Rule 14.
Examine shall pass by taking note of relevant law applicable in respect of the promotion. That's the Yeah, Mata. Yes, Mr. M. Boya.
Maybe.
It's already 12:25.
Well, the petitioner before your lordship are, my lord, already regular doctor, my lord, in the department.
But where is Mr. Gogoi? I think we'll need him. Find him out. All of a sudden, we can't take up a matter in the absence. Anyway, what is it, Mr.?
My lord, yes, my lord, they are, my lord.
How many are there? 1, 2, 3, 4.
Yes, well, they are, my lord, 4 doctors, my lord, regular doctors, my lord, working in the department since, my lord, more than 5 years, my lord. Accordingly, my lord, they have a quota, my lord, in service quota, my lord. And in this quota, my lord, one candidate, my lord, lordship kindly will look page 83, my lord.
Page 83.
Page 83, my lord, wrongly, my lord, this serial number,
Page 83, serial number,
my lord, 284, my lord,
serial
Aradhana-
number 284,
84, my lord.
284, yes?
Yes, this, my lord, Dr. Aradhana Mohantro is, my lord, not, my lord, in-service candidate, my lord. But as in-service candidate, my lord, right-hand side, my lord, quota, my lord, service health quota, my lord, SHQ, my lord, pediatric. at
She is
what-
not in service.
In
Why,
service.
why do you say so?
My lord, subsequently her, my lord, candidature was, my lord, cancelled from, my lord, complaint from various corner, my lord. But even then, my
No,
lord,
no. In service candidate means on the day of admission, he must be in service, or
Yes,
a
my lord.
past service of in service is also good enough.
My lord, this, my lord, entrance, my lord, 5 years to be completed, my lord.
She did not come. Yes, Mr. Gogoi,
Just the instruction I cannot.
that's what I am saying.
Yes, my lord, thereafter, my
No,
lord,
no, so now at 12:30, when counseling started at 12 o'clock, what order you want now?
my lord, here, my lord.
No, no,
one-
what order you want?
Four petitioners are there, not one man.
So, my lord, they may be also allowed to, my lord, their claim is that, my lord, because of our entry, my lord, and subsequently also cancel, my lord. Now, my lord, another counseling, final counseling, page 1898, my lord, is going to be conducted, my lord. But here, my
No,
lord,
no, what is your prayer now?
prayer is,
What order you want now?
my lord, I am praying, my lord.
See, if we have to cancel this Aradhana, that is
He's
this
already cancelled,
Mohanto,
my lord. Already cancelled, department itself, my lord.
department cancel.
Yes, my lord.
Then,
She is no longer, my lord, even in the service, my lord, just she is outside. my
no,
lord.
no, for admission to PG course, she is already cancelled.
Cancel, my lord, because it is subsequently, they say, my lord, it is wrongly given, my lord. Accordingly, my lord, if she is wrongly given, my lord, then, my lord, our counseling was, my lord, vitiated, my lord. And now, my lord, fresh counseling is going to.
Yes, Mr.
Well, for a slave vacancy, probably my lord, this counseling is held.
Yes.
They've already been.
No, if
advertising.
Mohanto's candidature is cancelled, that vacancy is there possibly. So for that vacancy, the next man should be called.
That my lord, without instruction, my lord.
Yet to be a learned counsel are taking instruction.
Obtain the information.
My lord.
This, if firstly obtain whether Aradhana Mohanto candidature has been cancelled.
No.
If, number one, if cancelled, against that resultant vacancy,
Right.
what the authorities are going to do?
My lord.
If you say that you have another more eligible candidate who will be considered, we'll record that. And if you say that nobody is there, then the best of this petitioner may be considered. The time is very less.
Yes, my lord, but my lord, she appeared, she was allotted in the department of pediatrics, MD pediatrics.
MD
They are in gynecology.
My lord, according to petitioner, my lord, had,
Four petitioners are there.
my
One,
lord, had,
He
my
wants
lord,
to say something according. Yes,
Malad,
according to the petitioner.
petitioners before your lordship also got seat, my lord. But according to them, my lord, had they, she was not wrongly.
Means petitioners are also entitled to MD pediatrics, and you are interested in MD pediatrics.
Yes, my lord, because, my lord, according to them, my lord, had she was not, my lord, entered wrongly in the final, my lord, counseling, my lord. Their entire, my lord, scenario would have been changed, my lord.
But now because of one man, we
Yes,
cannot
yes.
strike down everything and ask them to redo the
No,
entire,
no.
that is not possible.
My lord, in this.
Firstly, you tell us if the MD seat of in pediatrics of Archana Mohanto is cancelled, and that seat is now vacant, do you have any right to be considered for that? If you have, tell us, we'll ask them to also take note of your claim.
My lord, they have right, my lord, because, my lord, if, my lord, genuine candidate, my lord. would
No,
have-
that reasoning we don't know. Then we'll have to decide. Decide, we'll issue notice, we'll hear you on some future day.
No,
Today, what order can I pass? How can I presume that you have a right? And how can I direct?
No, our list is also there, my lord. Our select list is there.
Then how can the court can be converted to an admission authority now? Go and verifying all the list. How do you expect us
No,
to do
no,
that?
here, my lord, they are taking,
Show us in clear terms that if Archana Bhonto goes, one of these petitioner is the next man in line. If you can show it, we'll ask them to also consider your case.
my lord,
Otherwise, we cannot help you. Because there may be 100 people who will be entitled to this case. Why should we direct that only one petitioner should be considered?
And there will have to be a recast. of
And
that.
anyway, when the seat is vacant, they are going to fill it up by the appropriate candidate.
yes,
And if you are also an appropriate candidate, you show us, we'll direct them to consider your case.
they have, my lord, one notice, page 99, lord, you kindly will.
Mr. Gogoi, best you get the information. I can't, not possible for us to go into all
My lord,
this. Because if you ask us to decide, I'll now have to call for the entire record.
Yes.
Check up the list of all the 1,000, 2,000 candidates who is given where. Then find out. I need a whole day for that. We can't possibly do it. One way out, either you show us straight away through one document that you have entitled, we'll direct it, or else he says you have entitled, we'll direct it. Mhm.
Here, my lord, they, my lord, wrongly, my lord, entered, my lord, one person, my lord.
But Mr. Borbhuya, we have already rejected that argument. To accept that argument, we have to set aside the entire admission process that they have conducted and ask them to redo it once again. That is not possible.
Only, my lord,
Their claim
That is not
against the
possible.
State health service.
Because if one seat is cancelled, they have a procedure how they fill it up. They'll fill it up by that. And if it is you who should get in, they'll give it to you.
my lord, this is their, my lord,
At two in that. At two.
At two.
And my lord, one thing, my lord, they are claiming their, my lord, seat under the state health service quota. Not
Ah.
only limited.
only limited.
Some in-service people,
Yes,
they have a
sir.
quota for that.
These are the-
So for this seat in MD pediatrics for the in-service quota, if firstly find out whether Archana Mohanta had been cancelled or not. If not cancelled, there's nothing to look into it. If cancelled, whom are you going to,
Oh, I love that.
whom you are going to allow that seat? If it is somebody else, then also tell us whether these 4 petitioners have a better entitlement than the person you are proposing.
Exactly.
These 3 information is good enough for us.
Item 16,
Adjourn on the convenience of Mr. Yuken Nair. The
Last time.
request made clear that no further adjournment.
My lord, if
Matter
with
was
regard
heard earlier, no,
No. It's with regard to appointment of a post of principal.
it appears so, because Mr. Asketas. is there.
Matas is there. And be it, my lord. He's a master.
Because few council we know what's the subject matter about.
Then what happened, my lord? 96, I had obtained my BA. My lord, course was completed in 96, 97. Admission 96, 96, 97, course completed, but I failed in the examination. Then as a non-collegiate candidate, I appeared again and I got it. Thereafter, my
That is
lord,
acceptable in rules.
Acceptable.
Then it's okay.
acceptable in law. Thereafter, my lord, selection was held. I was recommended as number 1. When it went to the state selection committee, state selection board,
This is under which rule? 18.
under our my lord, secondary.
The 18 rules or
It
2003?
would be the, my lord, 18 rules.
18 rules.
18. Then it went to the state board. They rejected my case saying that you got your degree in 98, but the college did not have a recognition on that day.
Archana Sharma.
Also, no, sir. They had made the application in
The
96.
law is already decided.
Already decided. 96, my lord, they had made the application college. The principal has filed an affidavit. This was, my lord, somewhat rejected in 97. Thereafter, 98, 99, they made a fresh one, but the number was the same.
So Archana Sharma says that if the application is rejected also, it will, the course that is in between going on cannot be done. I completed the course, my lord. And when I applied for the next time, this time, my lord, I have got nothing to do with the college. It's with the university. Or the affiliating body, because they conduct the exam.
This,
and
this betterment or what exam?
whatever it is, my lord, I am a non-collegiate candidate. If that is-
University is Dibrugarh.
Dibrugarh University. But the Dibrugarh University gave me a degree. And the Dibrugarh University has also said that we have been allowing this college to run from 93, 94 onwards, and they are running. Only on that count, my lord, this was. My lord,
Very
Lordship,
short.
my lord will have page 47. My lord, the page 47, the recommendation, my lord. Khazarkhat Senior Secondary School.
Oh.
Biren Saikia, serial number 1, so and so obtained B.Ed degree from Bihupuria, so and so, as per the records. But Bihupuria,
Where is 47? Oh, it's in a horizontal form.
a horizontal form. Sorry, my lord, it was put in there. My lord, Biren Saikia, serial number 1, that's a petitioner, obtained B.Ed degree from Bihupuria PGT College in the year
Page
1998.
47.
47.
Okay, that clause 3.
Clause three.
Serial 3.
Lordship.
Viren Sharma, serial.
Candidate obtained B.Ed degree from Bihupuria PGT College, Bihupuria in the year 1998 as per records, but Bihupuria PGT College was recognized by NCT on 23/5/21. No provisional recognition of so-and-so is found during the period 97-98. But in case of Biren Bora, second empanel candidate was also obtained B.Ed degree from so-and-so, which was provisional.
Biren Soikia and Biren Bora.
Bora.
So both are Biren.
Biren Bora.
Your candidate is Biren Bora
Biren Bora.
and he is Biren Soikia.
Saikia. See, Biren Bora is recommended as a regular principal of Khazarkhat. Then I come up before my lord. My lord had an occasion to deal with the matter, my lord. My friend had come up before this honorable court. Page 58,
50.
WPC 1042, dated 11/8/2020. 59, the order starts. My lord would have 61. Para 8.
This is by Bora or Soikia?
This is by Bora.
Bora.
No, this is by Saikia. There was
It
an
must be
IA file.
Saikia because
Saikia-
Bihupuria College.
Sorry, there was a IA file. This is an order in the IA. My lord refused to, my lord, vacate the order.
Acha, this is IA by Bora.
Bora, there was a stay order operating,
In which
Fine.
writ petition? The present writ petition.
2057 of 2020. My
Then-
lord, what
then
final
what-
order is at page 62.
62.
Lordship.
Matter remanded back.
Matter remanded back for NCT to take a call and the government to pass an order. Now NCT takes a call at page 82.
This, yes. This is possibly a order before Archana Sharma.
No. It
This
was
one?
after also, no, sir.
After.
After.
Then why we did not,
My
why
thing,
why
Lord,
we
it's,
did
the
not
order
decide the
is,
issue then?
Persona Soma Tikiti. Pranita Sharma.
Pranita Sharma, not Archana, Pranita Sharma.
Oh, my lord, it's prior to that.
I think
Prior,
prior,
prior.
because otherwise,
It would not.
once it is decided, we are following it.
Then my lord, 82,
Is, just a minute. So we direct the NCT to examine what NCT is saying.
82, my lord. Bihupuria so and so. They remanded back to the government,
82.
82,
Who had remanded back?
the NCT. Eastern Regional Committee. My lord's order was taken into consideration. And they say before regulatory functions were started, 3, my lord, Roman 3. The petitioner has admitted for B.Ed course in so and so in the session 96-97, that is before the initiation of regulatory functions by the ERC NCT in Bhubaneswar.
So NCT, why don't you decide?
Now the government, no, my lord, that decision, government's decision has come. Because the NCT said to the government.
No, no, we
Government
asked the NCT, you decided.
And the,
Because you have the records, who applied on which date.
no, the application is on record now, my lord.
Anyway, what the government did,
They, my lord, send it back to the government,
page number,
page number 87, relevant 88, my lord.
page number 87.
16 March 2021. My lord would have the bold paragraph considering the matter. in its entirety.
89,
88, my lord.
88.
It starts at 87, 16 March 21.
See, Mr. Alam. Initially, many cases were coming on this subject matter. Earlier, we used to send it back to the NCT that you take your call because you are the authority. When you started not doing the work, we decided Pranita Sharma, I remember. Pranita Sharma was decided in the circumstance that it is better the court decide the issues rather than sending back and no one doing anything about it. That's why. All prior to Pranita Sharma, we requested NCT. When NCT did not do anything,
Then Pranita Sharma.
we had to take the call ourselves.
So, my lord, if the
Well, page number 80?
88, my lord.
88.
The penultimate paragraph, my lord. Considering the matter in its entirety and taking into consideration the report of DSC Assam submitted by letter number so and so, so and so, so and so. Recommendation of State Selection Board, the report submitted by ERC.
ERC 289 means at page 82.
80, no, my lord, that, page 82, my lord. So and so, held on so and so, affidavit submitted by so and so before Honorable Gautier, materials on record. It appears that the petitioner was a B.Ed student during the session 97-98, but he failed in the regular B.Ed examination 97 and passed in the examination only on 27-99. And the Bipuria PGT College was not recognized during the year 96.
The same issue ultimately.
Same. And so and so. Now, my lord would have the affidavit of the respondent number 6, the college, Bipuria College.
Page number.
Page 6 will be, my lord, 248 onwards.
248.
Lord would have 251. Internal page 3.
248.
It starts at 248.
Then
51, para 5. my lord.
relevant
Internal page
251.
251, para 5. my lord. Internal page 3. The answering respondent.
251 internal, the paragraph 6.
Oh, sorry, my lord. It will be 250 then. Sorry. 250.
5 is 250.
250.
I don't know, in my copy it's 250.
250. The answering respondent begged to state that Viren Sekha, a student of our college, was really admitted in Bipuria College. During the
Really
session.
admitted.
Really admitted. And then that too in bold. The petitioner under so and so appeared before the B.Ed exam 97. During that session, the institution did not have recognition from so and so. The petitioner also failed in the said session, and after he appeared so and so as non-collegiate
Well, this
candidate.
doesn't matter for
My
us.
lord would have the application at page, my lord, if lordship can have the
That
internal
is,
page 17.
Annexure 4.
Annexure 8,
Four.
my lord.
4, I think.
4.
Date of application.
Lordship, 4,
27
4, sorry.
496.
And annexure
4.
So 24/6/96, this was processed. My lord would have 2 pages, 1 page thereafter, my lord. 6/12/96. Northeast Council for NCT's letter. Internal page 13. This is the
Yes,
process.
Mr. Das, what is your submission?
Lordship, their application was rejected, so his case is not covered by Pranita Sharma's judgment. Lordship. He made their application on 6/12/96.
27 496.
Yes, and that was rejected by.
I think rejected very well.
Yes.
Then
at page annexure 5, page.
Yeah, we have,
260.
we have read that.
Yes, and then next lordship to page 261, annexure C. With reference to the subject cited above, your application has been rejected due to non-compliance of the requirement stated in this office letter number so and so and so. In future, you have to make a fresh application in the prescribed form following due procedure, which includes a demand draft. So there was no any pending application, their files were closed. So.
But
they-
you,
the-
the liberty is given.
Yes, but they did not apply.
Then did they make any fresh
No, no,
application?
sir, please.
Page 17, 24,698.
Page number,
17, Malad, internal page number 17.
into page 17.
Sorry, Malad, after our application at page, sorry, Malad, annexure 7.
That is after the cutoff date.
No.
18,897 was the cutoff date as was held by the.
No, we'll hear you, don't worry.
Malad, just clarifying the
We're
position.
just taking note of the facts now.
So, my lord, page 17, the.
17.
One
Where is the fresh application?
My lord, at page, annexure 7, page 15. My lord.
15.
15, internal page. No, my lord, in that affidavit itself. Internal page 150. Marking your own.
Yes, now what is Pointer Sharma? Let us.
Then, my lord, 17, my lord would have. Internal page 17, annexure 8.
Hmm.
My lord, here. Your application for recognition and subsequent representation dated so and so under
No,
consideration.
very well. Now, where is the recognition?
Recognition, my lord,
Page
This is the one.
266.
lordship,
Page 266.
lordship. 21.5,
Yes, 266, Mr. Nair.
lordship,
That's a recognition.
recognition.
So now, where is Pointer Sharma?
No interest.
Asim ji, बोले थे आपको बात।
Yes. I have a copy. My lord, para 7.
Just a minute. Yes, Mr. Das, what do you say of para 8 of Pointer Sharma? Who appears for the government? Paragraph 8, that where Supreme Court judgment is quoted. What do you say of that?
The institution is, section 41 is there.
Huh.
But lordship, in this case, lordship, The last date held by your lordship in contest
I
of
know.
judgment was 18/8/1998. And
Understand?
he had applied.
No, we are not on that.
No.
He was undergoing course of 1996,
96/97.
96, 97.
For 96/97, there is an intake capacity of 60 students and there was no recognition from the NCT.
No, that need not be.
Okay.
Supreme Court says during the pendency of the application seeking recognition and even in case of refusal of recognition,
Okay.
that is his case,
Okay.
the course may have to be discontinued
Okay.
only at the end of the academic year.
Yes.
So meaning thereby that from the next academic year, it will not be recognized.
Yes.
But he is already through in that given year.
His session was 96/97.
So 96, 97
Lordship,
will come to an end.
that was a 1 year.
It came to an end before 18/8/1997. So that is a valid course.
Lordship, that 96 session will come to an end in 97 because that was a 1 year course. And for that.
We are not only 1 year,
part-
2 year
for that-
course.
for that
We are
partic-
on whether the degree given by the Bipuria College
For that particular session, there was no recognition.
may not be, but Supreme Court says they have to be allowed to continue. So there is a legal fiction by the Supreme Court judgment that it is recognized.
Lordship,
Factual recognition may not be there, but there is a legal fiction in favor of a recognition by virtue of the judgment of the Supreme Court in Uttar Pradesh versus Bhupendra Tripathi.
There are also judgment I have brought. Which says Hyderabad.
Which judgment? Let us see.
In fact, also I prepared a written argument also.
Let us see what judgment you are referring.
Lordship, I will rely upon 2013 1 SCC 223.
Let us see.
Yeah, NCT versus finance policy.
2013 one SSC. Page 1. Page 2013 one SSC.
Which paragraph?
Lordship, paragraph, Lordship, I will rely upon paragraph 29, 32, 34, 35 and 36.
20, how much? 20?
29, 32,
29.
32, 34, 35 and 36.
No, 29. In Adarsh Shukla. Category.
One.
2013 1 SSC space 2.
That is a 29 is of no use. It's a regulation proceeding provision. 30 after laying that of his bench, there is a question posed.
No, shall not be declared.
This is also right. We accept it, but this doesn't help you. Para 30 doesn't help. Next paragraph 31.
Paragraph 34.
34. Let's see what is provided in 34.
That's where you have put-
It is the High Court could not have directed recognition. We are not directing. We are only relying on the Supreme Court judgment, which creates a legal fiction, not a factual fiction situation, legal fiction. That if an application is made within that time, even if that application is rejected, for that given year, it will be accepted. Only after the end of that year, it will not be accepted anymore. So he goes through.
He was a student of 96, 97. Ultimately, he passed in 99. For
It doesn't matter.
every
No,
session
no.
he has a intake.
Year of passing out is not relevant. Year in which you have undertaken the course is important.
Lordship, for 99 batch, Lordship, there will be a separate intake.
No,
procedure for
he is
this
not a
program.
99 batch.
Yes.
There's a relevant aspect is in which year you had undergone the course,
That
not
is-
in which year you have passed out.
Yes, he has undergone the course in 96, 97. when there was
96,
no recognition.
so 96, 97 the session has to be continued as per the legal fiction.
But their application has been rejected.
Even if it is rejected, go to the Supreme Court, get it reversed.
And the Lordship, the.
We are
even the-
bound by
even
Supreme
the
Court.
college has itself said in the affidavit that his degree cannot be considered. as a
See,
certificate.
There's a difference between a fact and a legal fiction. Supreme Court had created a legal fiction. What is legal fiction? Suppose on fact, Mr. Das is not standing here in this court. But there is a law laid down, there's a legal fiction that even if Mr. Das is not standing, he is deemed under the law to be standing here. Then we'll recognize even in your absence that you are standing here. This is a legal fiction. So factually, it may not be. But Supreme Court had made a legal fiction in their favor.
And Lordship, all the four authorities, Lordship, the
That
NCT.
doesn't
the
matter.
Vipuria
See,
PGT college.
See, when under the law, he is entitled to a right. Some authorities refusing it, not take away that right.
No, even the NCT has filed his affidavit in this case.
Doesn't matter.
Saying that his.
Even MCT cannot go against the law. If the affidavit is found to be against the law, then sorry, huh? I think we'll have to go against you, Mr. Das. If you want adjournment, one hearing, we can fix a date, but till now it is going against you.
Lordship will fix it, then Lordship, I'll try to set it. I also prepare.
Heard in part, list on so and so. The application of the Vipuria College which was made on 27/4/1996, page 258, annexure 4, for seeking recognition of the B.Ed course was rejected by the NCT by their communication dated 6/12/1996 by giving them liberty to make fresh application. Fresh application was made on 1/4/1998 and thereafter by the order dated 21/5/2001 of the NCT, recognition was given. In the present proceeding, a question for determination has arisen that the B.Ed course that the petitioner had undertaken for the year 1996-97, session 1996-97, would be a valid degree under the law or not. Admittedly, there is an application as indicated, dated 27/4/1996, and it was rejected on 12/6/1996. Therefore, factually, as on the said period, there was no recognition of the B.Ed degree offered through the Vipuria College. But the Honorable Supreme Court in state of Uttar Pradesh and others versus Bhupendranath Tripathi and others reported in 2010-13 SCC 203 in paragraph 29 had provided as extracted. It was page 80. No, a reading of the proposition laid down by the Supreme Court makes it discernible that during the pendency of an application seeking recognition, and even in case of refusal of recognition, the course may have to be discontinued, but only at the end of the academic session, meaning thereby that the course that was offered through the Vipuria B.Ed College for the year 1996-97 would come to an end only at the end of the academic session, meaning thereby that during the period of the course, a legal fiction had been created that it will not come to an end, meaning thereby it was an acceptable course under the law. Mr. S.K. Das, Land Counsel for the respondent, so 6 for an adjournment to examine the aforesaid proposition. This counsel.
Much.
Factually, yes, you are right.
In Ponte Sharma's judgment, your lordship held the last date as 18/8/97.
That will not preclude the court from taking note of a Supreme Court judgment.
My instruction, my lord, regarding hard typically must be applied online, counseling was held online. Those he was allotted that particular teacher in he did not turn up for admission. So that's why when that teacher
Online vacant.
only at the time of admission, when we verify the original. See whether it's otherwise than that.
But she did not come.
Might be she knew that my lord, that she has wrongly applied.
Anyway, so now how to mitigate the petitioners?
But here, my lord, as per order. This. It's been categorically, my lord, after the third round of counseling for all India quota or state quota, they will not be allowed to participate. We were at already.
So this seat will remain vacant.
No, it will be, my lord, stay vacant. It will be, my lord, that counseling will be held among those candidates who have not got any seat in the third.
Okay, not somebody who had got it. This petitioner got something. Okay, subject change will not be allowed. Meaning is subject change will not be allowed, but if somebody could not get any subject, he will get it. That's why whosoever is not allotted any seat, he will get it. Mr. Gogoi, one situation is coming to my mind. Which is the subject most in demand? Surgery? No, I'm just asking. No, surgery is one of the most sought after. Medicine. Suppose someone does not turn up for surgery. Okay. In the meantime, there are 10 seats for surgery, 10 already allotted. Then there must be 9-10 different categories of 10 seats. So the 101st number, who was not allotted anything, now will we get the benefit of surgery, the most preferred one.
Consideration will have to be given to all the candidates.
Everybody step by step may go up. Do whatever is under the law, you do it.
My lord, my learned friend, my lord, missed one thing. Well.
Missed something?
Yes.
What did he miss?
Here, my lord, Aradhana Mohanto was my lord valid candidate, and she did not turn up. This case is different, my lord. My learned friend, my lord, submitting on general law, my lord. But here, Aradhana Mohanto was, my lord, wrongly, my lord, came in our, my lord, quota, my lord. Your lordship kindly have a look, page 83, my lord. Simply, my lord, that is here.
No, but now who will determine whether she had wrongly come or she did not turn up?
It is already determined, my lord, wrongly.
Who will determine?
My lord, department already determined, and it is, my lord.
No, it is not determined. Had they determined, they would not have given the seat.
Then, my lord, there.
Then we'll have to issue notice. Here Sandana Mohanto.
My lord, stated in the petition, my lord.
Mr. M. Borhuya, in other words, today we cannot do anything.
Lordship, kindly just have a look the effect, my lord. Lordship, just page 83, Lordship, kindly below. Page 83, my lord.
Mr. Borhuya, we don't need page 83 to understand the effect. Effect we understand.
Yeah.
We are asking you what order can we pass today?
Because, my lord, here, my lord, because
See, if I understand you have rightly, if we accept Aradhana Mohanto to have been wrongly allotted a seat, because of that your legal right has been violated,
yes,
we'll have to determine first that Aradhana was wrongly given a seat.
yes,
Who will determine that? We cannot go in a presumption merely on the statement of Mr. Borhuya.
stated on what, my lord, and department.
Mr.
also.
Borhuya, that is your statement, not a determination. That will need a determination. So we'll issue notice, we'll determine it.
Yes, my lord. Therefore, my lord, another submission is that, my lord, we are allowed, my lord, to attend, my lord, first round, second round, third round, my lord. Within these three, my lord, valid round, my lord, our, my lord, fate seat college may be interchanged, my lord. But on the last hour, my lord, valid, my lord, round, my lord, as she was, my lord, wrongly entered, my lord, we could not, my lord, upgraded our position, my lord. Therefore, my lord, third round is, my lord, virtually our third round is vitiated in law, my lord, because of her wrong entry, my lord. Therefore, we are praying, my lord, in this current, my lord, today, which is going on, my lord, if we are allowed, my lord, then, my lord, everything will be normal, my lord.
We have to be notified. Almost notified. All candidates are-
Yes.
Because what Mr. Gogoi says, this vacant seat will be offered to the man who was not given any seat now.
Yes, sir.
If that is the law,
Yes, sir. If it is correct, my lord, I will give up the case, my lord.
I don't-
If she is, my lord, departmental
Mr.
candidate, my lord,
Bormia, your strong words are not having any impact on us.
this is my humble submission.
Your submission, but you submit on the law.
Yes.
The submission you are making requires a presumption that Mohanto was wrongly allotted a seat.
Yes.
We will determine that. It's only your statement as of today.
Yes.
We'll have to issue notice, we'll have to hear them, we'll have to see the credentials of Mohanto. Then we'll take a determination that she was wrongly allotted. We'll do it.
In case February is the last.
But today, what can we do?
This is my humble submission, my lord, because,
Sub-
my lord, because.
Submissions you can make in hundreds, that doesn't matter. Submission has to be acceptable in law.
My lord, today, my lord, yet, my lord, it is not completed, my lord, last round, my lord. If we are allowed, my lord, if she is wrongly, my lord, accordingly, my lord, we will our exercise, our, my lord, right, my lord. Nothing will be affected, nobody will be affected, my lord.
What?
If today's, my lord,
Sorry?
our, my lord, petitioners are
No, no,
already.
sorry, you didn't understand your last submission. What you are saying?
My lord, if, my lord, today, my lord, last round of counseling is going on, my lord, it is yet to be held, my lord, and my petitioner is already in the office, my lord, directorate, my lord, they are sitting there.
See,
If,
Mr. A.M. Borbhuya, if I direct one petitioner to be given the audience,
exactly, this is.
then there may be 100 others similarly situated. Why should? There is nothing like that, that you are more alert, you came to the court, so an additional right has been
My
created.
lord,
It is nothing like
this
that.
is, with all respect, my, this is writ petition, my lord, others are not agreed, my lord, they have not turned up, my lord. We are before your lordship, and they are sitting in the office, my lord. If, my lord, they are allowed, my lord, because apparently, my lord, third round is, my lord, vitiated in
Ask-
law, my lord.
If you can do it under the law, do it. We don't mind. We won't stop them from doing it if they want to do. Up to you.
Because other, my lord, they have not approached your lordship.
Then,
We also, we
no,
just.
no, Mr. Borbhuya, what Mr. Gogoi submitted, if I understand rightly, this seat will be allotted to the man who was not allotted a seat and otherwise merit number one of the non-allotted people.
Yes.
It will be given to that man.
Their choice.
So law gives that man a right. You are saying that that law will be not applicable because Mohanto was wrongly allotted a seat. It is your statement
Yeah.
till today. That statement has to be verified and determined whether it is right or wrong. Once after determination it is there that it was wrongly allotted, then we'll apply the law regarding wrong allotment of seat and we'll pass the order.
Then, my lord, with all the
But
respect,
today, how can I do it?
my lord, with all respect, my lord, with all respect, subject to my learned, then, my lord, accept, my lord. My lord, if, my lord, this petitioner, my lord, allowed to, my lord, this counseling, last counseling, my lord.
How?
If, my lord, Mohanto was, my lord.
No, no, where is your legal right? Mere approaching the court is not entitlement. There must be a legal right.
My third, my lord, the counseling in service candidate.
Where is your legal right to be given a third counseling after allotment of a seat? Show it.
No, my lord, I have also challenged, my lord, this third round in service candidates also.
Challenging is not the end of the world.
Because, my lord,
Challenging, you can challenge many different things in the.
because, my lord, we are called, my lord, in the belly third round, my lord, but we
See,
cannot, my lord.
we have already given you enough time. Till now, we have not understood your legal right.
Saying, my lord,
Your prayer is only a prayer.
fair, my lord.
Even God may not allow a prayer if it is not substantiated.
This
You
is
pray,
my-
you pray to God today that tomorrow let 1 crore money be deposited in my account. Will God give you?
Humble prayer before your lordship. Our, my lord, for the purpose which, my lord, we are called in the third, my lord, the round, my lord, of
Mr.
council.
Unless your verbals are not having any
My lord,
impact on us.
Then, my lord.
Show us your legal right, we'll consider. If you want, we'll take up after some time. Sit, think about your legal right, tell us.
It is, my lord, in their notice, it is already, my lord, provided, my lord, that in the, my lord, first, second, third, my lord, counseling those who, my lord, allowed to, my lord, in the participate in the counseling, my lord, they should not appear, my lord. But our contention is that, my lord, our third, my lord, counseling is vitiated in law, my lord, because we could not, my lord, exercise.
This is which round, Mr. Gogoi? Third round.
Over, my lord. This final, my lord.
The Supreme Court has provided that candidates who joined up to third round shall not be eligible to participate in further round.
Yes.
How can I overturn the Supreme Court order?
Here, my lord, third round is, my lord, third round, how to,
Mr. Borbuya, you can go on uttering the same thing again and again.
my lord, if,
I
my
can
lord,
allow you
if,
time
my
up to
lord,
4:30.
one person, my lord, put our before us, my lord, then how, my lord, we will exercise our option in the third round, my lord. There, my lord, outside, my lord, candidate put in our seat, my lord, in the third round. Therefore, we could not, my
I
lord.
think there is a word called enough.
Yes,
I think we had enough. You are repeating the same thing.
this is the, my lord, my case.
What case? Either you show us that Mohanto was wrongly allotted, that has to be determined. We cannot do it. It's only a submission. Number one. Number two, you overcome the Supreme Court order that beyond third round also, this is possible. Either of the two, if you can do it, we'll hear you.
Third round, my lord, I admit, my lord, but third round, my lord, how we are deprived from the third round, my lord, because one, my lord, outside candidate has been entered in our, my lord, quota, my lord. Therefore, we could not go to that post, my lord.
Okay.
Therefore, my lord, I am in challenging also third round, my lord. This is initiated in law, my lord. We are paying, my lord, reschedule of the third round, or, my lord, in this round, my lord, we may be allowed to participate, my lord. If we are allowed, my lord, today, my lord, counseling, others have not come, my lord. And this is limited.
All the valid candidates.
Everybody, I don't know what you say. But you are refusing to understand. What can I do? You can go on arguing. Yes, I'll hear you.
My lord, this is.
I'll go on hearing.
Your lordship may consider.
No, we're giving you the offer once again. You can sit with a cool mind, think of any legal right. Tell us. We'll definitely look into it. But we just cannot get crash everything they are doing just because one man wants it somewhere. That will be highly improper.
Or, my lord, they may verify, my lord, if Mohanto was, my lord, not in service candidate, my lord, then we may be allowed to, my lord, counseling in this round, my lord.
Who will determine that now?
The department, my lord, will department.
We'll issue notice on that issue. We'll determine it. But order cannot be passed today. That's a difficulty.
They have, my lord, done.
See, court should not whimsically pass orders also. Every 226 based on a violation of a legal right. First, you establish your right. That is what we are repeatedly telling.
Our, my lord,
Again, this-
third round is, this is my humble submission, your lordship consider.
Very well.
Third round is, my lord, for which purpose our in third round, my lord, our call for, my lord.
The petitioner, Mr. A.M. Borbhuya, strenuously urges upon that the third round of counseling was not as per law. Respondents to respond on the said submission by filing affidavit. And the petitioner to also substantiate why the third round of counseling was vitiated. Ultimately, what you want to, everybody's seat should go.
No, seat will not go, my lord. It will be remain as it is. Just, my lord, our college and seat.
Mr. Borbhuya, do you feel that you are reasonably arguing something before the court? Or you are more emotional with your clients?
My lord,
It appears you are more on emotion than a legal reasoning. Please take rest for some time. Think about the legal right. Tell us if you have. Emotions have no place in a court of law. Next item, we'll hear you again if you want. Mr. Gogoi, bear with Mr. Borbhuya.
my lord,
If you can find out some legal right, we'll hear you.
At 3 p.m.
Sorry,
At 3 p.m. my lord. At
you
3
cannot
p.m.
fix your time. You have already given time twice today.
Item 13 and 14.
Where is Mr. Mondal gone? First, we want to know, Mr. Mondal, which document was given to you, which is not on record? Page number.
Yes, 73. 73, 74,
Page 73, 74.
75, 76.
Okay. Now, from the records, you show us whether you have a copy of this page 73, 74 or not.
Seventy-four to 76 is there and 78 is not.
74, let us see from the record, page 74.
Just yellow flag mark.
Yellow flag markings, please. Hmm. What about 75? No, 75 is also here. Next page, I think. Next page is 75.
75 is serial number 7.
Huh.
A format for
No, 76 is also here. Then 78 is separately, no? 78. No, 78, my page is different.
It is from the SLC law, it is another file.
Not this one, 78 is different.
Particular the home track.
78 to the file. 73, 4, 5, yes. We found it in the record, and 78, just check out.
78.
Yeah.
Yes, this one. The other one.
Other one,
Yes.
that page.
Yes.
No, that page is not 78. Check out. It's something different.
A part of this.
It's an extract. Extract is okay. Extract is permissible in law. Yes, Mr. Mondal, why did you make a submission? It is not on record. The respondents of with reference to the order dated 12/5/2023, wherein it is recorded that as to how under the RTI a different document which is stated to be not available in the records of the Deputy Commissioner Dhubri had been furnished to the respondent 7 and 8, comma, we required the presence of the State Public Information Officer cum Deputy Director of Elementary Education Assam to produce the records which may contain the documents provided to the respondent number 7 and 8 under the RTI. In response thereof, the records is the original records. No, we want that. Find out in the original record it is there or not, not your all these subsequently retained records. So according to this officer, he had given it from this record. The records from which the said documents under the RTI had been provided as 1, 7, 8 and 8 had been produced before the court. Upon comparison of the documents provided under RTI, which is available at pages 73, 74, 75 and 78 of the paper book. It is noticed that the said documents do tally with the records produced before the court, meaning thereby that the assertion of the respondent number 7 and 8 that documents under RTI had been provided to the said respondents which are not available on record is incorrect. Respondents numbers 7 and 8 to show cause as to why an incorrect stand was taken before the court without verifying the actual records. List again.
Item 2.
Presence of the officers dispensed with. Item number
2.
We can't pass over for twice. No, rejected. Yes, Mr. Sarwania, what is your matter?
My lord, they have not, my lord, till now no.
Passover time being cannot be repeated again and again, madam. It's only available once in a day. Sorry. Who is the secretary? Who is on leave? Secretary is on leave. Okay, then we stay the suspension for the time being. We'll hear you. And heard Mr. M. Sarwania, and counsel for petitioner, your name, madam? B? For the KSC, for the Karbi Anglong Council, the KSC and higher education who appears. Mr. K. Gogoi for the authorities under the higher education department of the government of Assam. An order dated 3/7/2023 of the additional director of education, Karbi Anglong Autonomous Council, Gifu, is sealed in this petition, whereby the petitioner, Dr. Harvey Inki Katharpi, Assistant Professor, Department of History, Rukasen College, Bokolia, was placed under suspension pending trial of departmental proceeding in violation of for violating rules 3 and 7 of the Assam Civil Service Conduct Rules 1965. The impugned order of suspension was assailed on 2 grounds. Firstly, that the additional director of education, Karbi Anglong Autonomous Council, did not have the jurisdiction to issue the order in as much as higher education, college education is not a transferred subject. The second ground urged upon is that as propounded by the Honorable Supreme Court in paragraph 21 of Ajay Chaudhary versus State of Haryana, or in State versus Union of India, reported in so and so, there is a requirement of the charge memo to be issued within a period of 3 months from the date of the suspension, or in the alternative, the authorities to conduct a review regarding continuation of the suspension. As regards the first ground, by our order dated 9/10/2023, we have already arrived at a conclusion that college education is also a transferred subject to the autonomous, to the KAC. And accordingly, we cannot conclude that the additional director education KAC did not have the jurisdiction to pass the order of suspension. But as regards the other ground, we required the respondents in the KAC to provide the information as to whether the charge memo had been served on the petitioner after the order of suspension, or as to whether any review regarding continuation of the suspension order had been conducted. The said aspect would have to be looked also from the point of view that it is the categorical statement of Mr. M. Sorenia, Learning Council petitioner, that no charge memo has been served on the petitioner as on today. But no information is made available as to whether the charge memo had issued or any review had been conducted by following the law laid down by our Supreme Court in para 21. So the order of suspension dated 3/7/2023 shall remain stayed till the next returnable date, on which the respondent KAC is given a further opportunity to produce any material, whether the charge memo was issued or whether any review was conducted. List on so and so.
There is a ground, my lord. The Lord and the authority, who's been suspended, my lord, Lord and the authority.
I think you have got the interim today. He was it on the next day.
My lord.
In November.
I love it.
Time being item 4.
That matter. Yes, Mr. Chisti. Then we stay this transfer. No, if you want, you can initiate a proceeding. We have no difficulty because the allegations require something to be looked into. But that will not result in you go there and you come here. Heard Mr. N. Nathan, counsel for the petitioner, also heard Mr. SMT Chisti, and counsel for the respondents in the elementary education department. Issue notice written for 6 weeks, extra copies 3 days, steps on respondent number 6 registered post 3 days. An order dated 15/9/2023 of the District Elementary Education Officer Dhubri is sealed in this petition, whereby the petitioner Anima Devnath, assistant teacher and in charge head teacher of 1475 number Goripur Girls LP School, was allowed to work at 562 number Dumar Doha JB School as an assistant teacher. And the respondent number, what was the number? 5. And the respondent number 5, Bornali Devnath, assistant teacher of 562 number Dumar Doha JB School, was allowed to work in 1475 number Goripur Girls LP School with immediate effect. The order further provides that the matter of transfer will be placed before the district level committee for transfer, meaning thereby it was an order, meaning thereby that the impure order would be an order of transfer without being placed before the appropriate district level committee for transfer. In the circumstance, we required the respondents in the elementary education department to provide the relevant materials to the court as to why the order dated 15/9/2023 was issued. In response thereof, Mr. Chisti. In response thereof, an inquiry report dated 10/8/2023 of the Sub-Inspector of School Goripur had been placed before the court, wherein paragraph 2 and 3 are as extracted. We have to give a copy. We'll quote this one.
Yes.
Where extract a reading of the aforementioned extracted provision in the inquiry report dated 10/8/2023 makes it discernible that the petitioner, being the in charge head teacher of the school, had certain issues with the cook of the school regarding the midday meal being provided, and that on 9/6/2023, the petitioner was busy on the mobile phone, and at that time, the husband of the petitioner came to the premises of the school and had misbehaved with the cook by saying that he would be hit with a sandal or a shoe. A communication from the sub-inspector school, who was the inquiry officer, dated 11/9/2023, is also placed before the court, in which it is stated that after the inquiry report, the petitioner had threatened the sub-inspector of school as regards the report that may be submitted against her, which again is extracted as below. Green, second green too. Mr. SMT Chisti, learned counsel for the respondents in the elementary education department, seeks to justify the order of transfer based upon the inquiry report dated 10/8/2023, as well as the communication dated 11/9/2023, by which there is an allegation that the petitioner had threatened the sub-inspector of school. Even if we accept the aforesaid two reasons, we have to understand that the reasons may result in a misconduct that may have been committed by the petitioner. But the remedy thereof may not be in the form of an order of transfer being issued, and that too without completing the process of placing the same before the appropriate committee of the district, transfer committee of the district. In view of such prima facie case being made out, the order of suspension dated 15/9/2023 is stayed. But however, because of the alleged misconduct against the petitioner as noticed above, we leave it to the discretion of the authorities to take any appropriate action against the petitioner as may be advisable under the law. And staying the impugn order transfer dated 15/9/2023 shall not be constituted to be any bar on the part of respondents to take any appropriate action if otherwise advised. It is noticed that as because of the allegations as indicated above, The district elementary education officer had issued the show cause a notice dated 30/9/2023 to the petitioner. But it is candidly admitted by Mr. S.M.T. Chisti upon instruction from the district elementary education officer that the said show cause notice may not be the appropriate course of action in the matter. If it is so, again, liberty granted to the district elementary education officer to take appropriate action if so advised. And pendency of this writ petition would not be a bar in any manner. This after 6 weeks. Sorry, there is no suspension order.
Only the transfer order notification.
Transfer order we have stayed. The show cause notice dated 30/9/2023 also. Where is the word suspension? No, 39. Q, where is the word suspension? No, where is the word suspension? You are saying he's suspended, but where is it? You. Umbrella. It is noticed that by another order dated from the record is noticed by another order 5/10/2023 of the district elementary education officer. The petitioner was also placed under suspension. We are clarifying that we are not interfering, not passing any interim order against the order of suspension dated 5/10/2023 in as much as it is not a subject matter of the writ petition, present writ petition. Transfer order is stayed.
Yes, it was transferred and one Bonali Devnath was against, but Bonali was not get part of this. Someone Siyan that one was taken. I think that is or phase 5 document.
Yes, Mr. Nath. Priyanka Biswas, why Priyanka Biswas is a respondent and not Bonali Devi Devnath.
Because perhaps this Priyanka Biswas was allowed to assume charge of the headmaster by page 67. There.
No, but once he suspended, this man comes in, this one automatically goes. Respondents to array Bonali Devnath as respondent number 6. And the registry to incorporate necessary correction as well as in the writ petition as well as in the CIS system. Notice by registered post be also issued to respondent number 7 Bonali Devnath.
Timing 8.
Mr. Chisti, your authorities are creating a bench. If Bonali Devnath is brought in, she is an assistant teacher. Petitioner also an assistant teacher. LP school does not have a headmaster. So one assistant teacher is made the in charge headmaster. Now Bonali Dev was not made the in charge headmaster. You bring in Priyanka Dev Biswas as a headmaster. Now we'll have 2 teachers in that school. It's all kind of. Yes, Madam Ghosh. What is the matter?
Item 8.
Will be appearing. Yes, Mr. Sharma, please call Mr. Nair. It was adjourned in the morning in his name. Second time we cannot adjourn. Don't make the prayer. We can't help it. We can't repeatedly go on adjourning. We're starting the hearing. You do whatever you want. Or else we write none appears. We'll pass our order. Yes, madam. What is it?
Yes, my lord. Petitioner was
before fixation, Lordship, petitioner was initially appointed as a grade 2 officer, stenographer. Then subsequently, by order dated 23rd of January 2017, he was promoted as grade 1 stenographer, Lordship, a senior personal assistant, which is annexed in page number 35, Lordship.
Yes, 34.
Page 35, Lordship,
13 with
senior personal assistant,
Yeah.
Hasnin Alam. So his is 12,000. His initial pay is pay band 4, initial pay is 12,000 plus his grade pay 5,900 plus.
So
PS
this is pay as it existed in 2017.
Yes, when he was promoted.
Huh.
So 12,000 plus he will get grade pay of rupees 5,900, Lordship, plus PSP, Lordship. PSP order is there at page 33, Lordship. That is principal sick pay. So pay band 4, he is in pay band 4. So his is 12,000, 1,250.
So they have given one formula.
Yes, Lord.
Basic pay is equal to pay in pay band
Pay
plus
band
grade pay plus
plus
PSP.
PSP.
So these three components will comprise the basic pay.
Yes, Lordship.
Okay. What was the basic pay in 2017 when the man was promoted?
Same. He received, and I have
No, what was the pay band? 12,000.
12,000,
Okay. And what was the grade pay?
5,900
900. So 12,000 plus 5,900.
plus
It will be 17,900. And what was the PSP?
1,250,
1,250. So it will be
19,150.
19,150.
Yes,
Okay.
Lordship.
19,150. So this was given.
This was given.
Now
Yes,
given. So now what is the grievance?
when the fixation was made.
Fixation means
7th pay commission. This was
the revision of pay.
revision of pay.
Okay.
That was under the 6th pay commission. When the
17, that in 17, when the man was promoted, he was covered by the 6th pay commission.
yes,
Now, after revision of pay by the 7th, he'll be placed in the 7th pay commission.
yes, Lord.
So he'll be governed by the same formula.
Yes.
If we understand
Yes,
rightly.
Yes. So if we see page
So now,
40,
what is the grievance of this petitioner?
he is not getting the calculation is wrongly calculated. He is not getting the amount which he is supposed to get.
What is he getting now?
He much less than
No,
that.
no, okay,
PS
no, which page do I get the figure? What he is getting?
Page 40, Lordship.
40.
40, Lordship.
No, what he is actually getting?
He is actually getting, Lordship, is less. Just let me just explain this, then I will show the other thing, Lordship. Then, so he is before the fixation, since 6th pay commission, he was getting 12,000 plus 5,900 plus 1,250 is 19,150. So if we see page 40, Lordship. Page 40, serial number 4, Lordship. He will be fitting in serial number 4. 19.
Okay, as per that one.
Yes.
Huh.
So since prior to that 19,000 and in between 19,150. So he cannot.
No.
fit.
Why will he fit into 19,500?
Reason is that 19,000 is is less than what it is fixed, 19,150. So
No,
rule is
no,
that
this is on the revision of pay.
this is, before revision, he has to. be
This
fitted.
page 40,
Yes, Lordship.
it's related to before revision of pay or after revision of pay.
It's both.
It cannot be both. It has to be either of the two.
Reason is that, Lordship, the comparative table is given there. Let me explain. Lordship, if kindly turn down to page 40. So,
Okay, can I have the complete copy of this page 40? It's only one page.
yes, Lordship.
What is that document?
Yes, Lordship. I have ROP rule.
Hmm? Here's a sheet of paper, you have a big book.
No, the entire one. That's a different bit, which is appended to
No.
the, as an appendix to the rules.
This page 40 is this one, a part of this document.
Yes,
Just let me go through it. Where is that page 40? It is not here.
This is for Assam government, so PSP will be added. So if
No,
we
no.
pay structure, if we come.
I just wanted to see because page 40 is not the complete document. It's a photocopy of one of the pages of
Yes,
that document.
Yes, Lordship.
In fact, it is page number 334 or whatever document.
Yes, Lordship.
Can I see the complete document? Then only I'll understand what is this.
That is the entire.
Appendix 1 of ROP rules. This is appendix 1 is related to which rule? Acha, this is ROP 17. Huh?
17, entire.
They shall be deemed into community effect from April 16. Unless these officers and staff of Guwahati High Court is included. Relaxation of rule definition existing. So, Mr. Nair, okay, this we understand what he is. Now this man, if you come to page 33, that clause 2, administrative officers over the Guwahati High Court to their respective pay for determining the basic pay. Huh? That pay band is the basic pay. We all understand. Basic pay is pay in the pay band. Okay. Now pay in the pay band is, if you come to the appointment order, just now it was shown to us. Page
Yes,
number
35.
35. Page 35, he is appointed at PB4, 12,000 to 4,000, 40,000, plus grade pay 5,900, plus other allowances. So this is the terms of the appointment. Now, if we calculate the basic pay of this person, it is pay in the pay band, that is 12,000. Grade pay is 5,000, so it comes to 17,900 plus PSP.
125.
Huh. 1 to, so it will be
150.
150 as per the calculation of the petitioner. So 150. Now, after the revision of the pay, just a minute. Let us put the question. Now, after revision of the pay, had there been no PSP, this man would have been at serial 1 of page 40 because 17,900, 1,200 plus 5,900. But the law provides them that PSP will be added to your basic. So once we add, it is 19,150. So 19,150 will be clause 4. So now after the revision, this man will get 19. So he's at the time of revision, he is 19,570. So correspondingly, he will be 47,320. But what is being paid? Page number?
43,330.
Huh. With page number? Some calculation was shown somewhere, no? Or Mr. Das showed it the other day. Somebody showed it to me. Yeah.
It will be paid 63.
63. So now his revised pay is becoming 37. That is PPB plus GP plus PSP is now said to be 37.
Plus 1,250.
No, forget about the plus and all. That will come later on, those TADA and all. Now, whereas as per page 40, it ought to be 47,320. But as per page 64, it is calculated to be 37,160. Why?
Can I just try to answer? The confusion here is, it's not even the fault of the petitioner. We have also taken up the matter with the finance. Because the final call is with the finance.
No. Final call is the law, not the finance.
Fine.
Finance is only an executor of the law.
The confusion here arises because of page 40.
Hmm.
My lord will take up page 40.
Yes.
This is the fitment table. Here PSP is not being provided. The government has not made a provision for PSP. Now, how do it do? If your lordship can.
See, Mr. Nair, PSP is provided for all time to come. It need not be provided in every revision of pay by 16th August 2016.
It's there. They'll get, if they promote it.
PSP will always be paid.
It is given by PSP. It's not that the PSP is not given. PSP payback, basic payback is, or basic pay is not taken as a unit. My lord will only for a minute, my lord, leave this revision, just let me for my understanding. Basic pay is taken to calculate the other benefits, DA, HRA, MA, etc. Now, the basic pay concept normally for government service would be grade pay and payback. On that, my lord, the 27% interest,
Everything
will be done. Now, for an high-court employee, basic pay, payback, grade pay plus PSP 12050 or 1110.
Whatever it is PSP.
That is calculation would be. Now, the question of fixation.
What is fixation?
Fixation means, my lord, when there is a changeover from a regime under 6th pay to a new regime under 7th pay commission. When this has to be fixed, then, my lord, the contours would change. How it changes, I'll fix it. He was there in service in 2016 as a grade 2 stenographer. The effect of the revision is from 1/4/2006. This came much later. In the meantime, my lord, in 2017, he was
Promoted,
the date is my lord 23/1/2017.
with a little,
Lordship.
if that is the case, when the revision of pay scale is given effect with retrospective effect, till the day he was not promoted, his revision of the scale will be in his unpromoted post. And from the day he was promoted, it will be on the promoted post.
First, as of 1/4/16, wherever he is, his pay has to be revised. Then,
So 1/4/16
Lordship,
up to 23/1/17,
this has to be revised.
his pay will be revised in his unpromoted post.
Now,
From 23rd January, it will be in the higher post. So now, from 23rd January, what is paid to this man?
if my lord can come back to 63 with that understanding.
63.
Lordship. My lord would. find-
This I never understood.
I
I've been taken through this many number of times.
Even to me, my lord, it is still a bouncer.
I don't know how you have understood.
It's a bouncer. I'm only trying to project before my lord. I'm not saying my lord, it's with much of other thing. I'm just trying to project what they are thinking.
No,
Beyond
no,
that, my lord,
Mr. Nair, we cannot go by the thinking of an accountsman.
No.
We have to go by the
we
law.
have to go by, but I
If
think, my
a
lord,
man is entitled under the law, accounts will have to modify their stand.
they'll have- And if this is done, my lord, it will be benefiting all this stuff,
Everyone.
everyone.
And our view is, if the law provides something, somebody,
He has to be given.
it should be given. Why will you not give it?
My lord, only BMP, if I can just get
Huh.
across what I'm trying. to say. Now, my lord, the pre-revised scale as on 31/3/2016 was 8,000, 35,000 mid pay, 4,300 PSP 1,000. My lord,
Sorry, pre-revised pay,
that means my lord, on 31/3/2016,
hmm,
he was drawing his pay on
31/3/2016.
His pay band was 9,250. His GP was 4,300, PSP was 1,000. My lord, got it?
Hmm.
He was drawing his basic pay of 14,550.
Hmm.
Then, my lord, this scale is to be revised
Hmm.
under the 7th pay commission.
Hmm.
His revised pay as on 1/4/2016
It
scale,
became 22.
revised pay as on so and so is 37,160.
Huh.
On 1/4/2016, his pay became
22. So now I don't know. Now the appropriate calculation should be 22,000 is the PB,
Lordship,
9,400 is the grade pay.
Lordship,
You add to it,
Lordship.
it will be 31,400. And then add TSP of 1,000, it will be 32,400.
It would be, my lord, 27,016.
32,400 plus whatever allowances and DA and all he gets.
It is different. It would be 37,160 on 1/4/2016.
Why?
My lord would have page 37, let me clarify.
Pays?
Page 37.
Hmm.
My lord would have 6 existing pay structure
Huh.
was this.
Huh.
Then it got revised.
Huh.
So basic pay in the pre-revised was 14,550.
Huh.
Now, the pay scale
This is where basic revised is.
my lord, I'm just placing it. The starting was 22,000, 97,000 was the ending pay band.
Sorry.
The pay band was, running pay band was 22,000 to 97,000. Revised.
Huh.
Earlier it was 8,035.
Huh.
That got revised to 22,097.
Huh.
Now, in that pay band, he was placed at 27,060,
Hmm.
27,068. In the revised pay of 22,000, 97,000, because he was there for some time, he was getting some increments. So his pay got fixed at 27,060.
Instead of 22, it is 27,000.
Because he's there for some time. So he might have gone up from 8,000 to, my lord, he has gone up. from
So no,
8,000.
that was in his
Pre-revised.
no, that was in his pre-promoted.
I'm on that only. I'm on that. Then he was given a grade pay of 9,100. In that revised non-promoted post. Then principal pay at that post was my lord 1,000. His total
This is pre-revised, pre-promoted.
Basic pay.
Pre-revised, pre-promoted.
Pre-revised, pre-promoted is 37,160, which is there at page 63. 37,160. Now what is it, my lord? He gets an increment. Increment is on July. So on July 2016, he gets an increment. His pay goes up, his basic goes up to 38,280.
38 to wait, very well.
My lord, now the promotion next. 23/1/2016. By the time this 8,000 gone, now his pay is revised. He is at 38,220. Now that has to be fitted in the.
No, this is where we are not agreeing. Moment he is promoted, he will have the pay structure provided to him in the promotion order.
Only on that figure. That 38,220 is the base. He is drawing it, and that's how one of the fitments are made. He will be on that basis placed in the new pay scale of the promoted post.
New pay scale, revised or pre-revised?
Revised.
How? How a pre-revised figure is now going to be revised?
This is already revised.
Where is it revised?
My lord, that page 63. My lord will only have page 63. His pay 1,416, grade 2. He was revised to 37,160.
Very well.
Then increment 38,220, 280. Now the promotional post from 23/1/2000.
Very well.
He'll have to be placed there. How they placed it, my lord will see in the middle. Promoted to post of stenographer grade 1 private sector. Scale, new scale, revised scale. 30,000, 1,10,000. CP.
No, from where do you get 30,000 from page 40?
Oh, my lord wants that in. My lord will have page 40, top portion.
No. See, the day the man is promoted in the higher scale, he is in the pay band and all provided at page 40. There is absolutely no dispute to that. I don't know how you fit him. I don't know how he is not fitted.
That scale will be applicable.
And this scale will be applicable because he, on being promoted, he is entitled to
30,000.
no 12,000 to 40,000.
No, man, that is pre-revised. Left hand side is pre-revised.
Which
Right
one?
hand side is revised.
Which yes, we are coming to that because this revision came into effect
From 1/4 to
1/4, but he was promoted before that.
after 70.
No. You are, Mr. Nair, you are giving effect from a retrospective
But the
date.
orders came subsequent.
Orders came. So on the day he was promoted, there was no order of pre-revision.
No.
Clear?
No.
So he is put in a pay scale of 12,000. You cannot pay him a single rupee less than that
Gotcha. Gotcha.
on that day.
Gotcha.
Then you have to pay him a grade pay of 5,900. So that is 17,900. By going by place 33, you add
1,200.
1,200. So he is on 19,150.
That's the.
So moment it is, he is 1950, and the day you implement the revision, page 40 will be applicable. He will be covered by serial number 4, and he will be put in the pay band of so and so, having a total pay of 47,320. Problem cannot be an answer to the entitlement under the law.
The page 40, if the PSP is taken, then it cannot be applied to anyone. Give me a
What?
record.
What?
If PSP is to be taken into account, it's being not provided there. The page. 40
Just a
cannot be-
minute, just a
cannot be
minute.
applied.
No,
And
I
how
think,
PSP
I
is
think
to
we
be-
are disagreeing with that. Come to page 33.
Gotcha.
PSP is provided for all time to come. It's not to only one.
PSP not.
So moment PSP is provided, the same formula has to be adopted.
Here, then my lord, the question would be, the pay that he is drawing from the lower post, which is being fixed, my lord, contains a PSP, 1,000,
Which one?
lower post PSP,
Huh.
higher post, another PSP is to be added.
No, another no, you are wrong. In the higher post, we have forgotten everything what is getting in the earlier one. This is the difficulty, there's a
That's
cog
what
in
the
the
feeling
mind
is.
of the accountant.
Feeding is.
There is a cog in the mind of the accountant.
And I'm sorry, my lord,
Whatever PSP, whatever he was getting in the lower post, that comes to an end the day he is promoted. So the day he is promoted on the scale of 12,000. So that is his minimum pay band. Add grade pay. Then freshly you add the
my lord,
PSP,
gotcha.
because other PSP, whatever is,
It's first.
that's over. Huh. That he'll get
That's-
for the day up to the day prior to he was promoted.
That's unclogging my mind.
So, so the day he was promoted, he's entitled to this one.
Gotcha.
So his now basic pay is 19,150.
I got it. If it is
Moment it is 19,150,
19,500.
the day you put in the revision, it will be the corresponding revision.
Gotcha. That's one way of putting it. But my lord, my lord said it's my feeling. I'm agreeing with my instructions. I can't-
No, you asked the
No,
accountant.
no, no, I'm not on that. There is an issue on that, which my lord will have to address.
Yeah, we'll decide.
Lordship,
No
If
difficulty.
lordship can come to the affidavit filed by the finance. Because this. would
Now
be
let
about-
us read the notification first.
My lord, PSP, my lord, what my
Uh,
lord. has
The,
not told me
the
about-
writ petition,
Nothing
and I think it's a part of a judicial order.
My lord,
As
Yes.
approved by the cabinet, is pleased to approve payment of register to the officer in charge.
my lord,
This is continuous.
PSP, what has fallen from your lordship, nothing is beyond there in the notification.
Hmm.
It's there.
It's a continuous. As long as it's withdrawn, it is there.
My lord will come to page
Page
7
7 of,
of the affidavit filed by,
any idea of the running page number?
my lord, it will be the last.
Utpal Tamuli, that one.
My lord, it's.
By Utpal Tamuli. Yes,
My lord will come to page 7,
internal.
internal.
Hmm.
My lord, we had, when this issue came, we had taken it up with the finance,
Hmm.
not once but twice.
Hmm.
This is the second reference.
Hmm.
Petition number so and so, with reference to the above, I'm directed to say that the prayer of the petitioner has been reviewed and his pay scale has been refixed as un. Officers and so has allowed bail, my lord will leave that. Accordingly, fixation has been done in respect of so and so in the following. As per rule 11 of Assam, ROP rules 2017, read with 22(1)(a)(1).
See, Mr. Nair, straight away I'm pointing out the mistake.
Lordship,
Come to the clause 3 fixation.
lordship,
Last pay drawn in the lower post.
lordship.
Once he is promoted, you have no business to take note of what he got in the last post.
Fine.
Everything is made on calculation of that basis.
Lordship,
Because the day the man is promoted,
Lordship,
He comes to the lowest of the scale in the promoted post. Always.
I beg to differ. my lord.
Why? Under which
Why-
proposition
why-
of law?
Why I'm saying so? My lord, I can't go with these big numbers and take small. numbers. Say, my lord, the scale is 1,000 to 9,000. I join.
No, no. Before you explain, let us ask you.
Lordship,
Once a man is promoted,
Lordship,
say in the original post, he's 100 rupees. Forget about the scale and grade pay and everything. In the promoted post, it is 150 rupees. Okay, minimum. In the promoted post, by virtue of increment, etc., the man had reached 130 rupees. Day he is promoted, he will take note of 130 or he will take note of 150.
we can 150.
This is what is not done here.
My lord, I'm on that.
This is what is not done.
It has been subject to correction. It has been.
Why it is not done?
I'll show you how it is done. My lord, lower post, stenographer grade 2. Pay structure is this, date of release is this, last pay drawn is rupees 38,640, wherein my lord PT is so and so, grade pay TS. Now the higher stenographer grade. Pay structure of the post 30,000 so and so to 13,300. Date of joining is this. Now how they have done the calculation. Fixation of paying the higher post on the date. of-
Mr. Nair. Earlier days, when this so many banks and financial institutions were not in existence, people used to take loan from
That money lender.
Mhm.
And that was.
And there is a term in Assamese called Kavalir hood. They have a peculiar way of calculating,
Per day.
but it is their
They will-
their prerogative. They give loan, they calculate, you have nothing to say. But now we are in a structured provision of law.
And I,
Any kind of calculation the department wants to make, unless the basic logic is available, why should he accept it? Because somebody thinks like that.
well,
Firstly, you tell me,
I can.
in
tell
my
you,
example of 100, 130 and 150,
I cannot
the promoted man can never start his pay in the promoted post from 130
My lord,
because he was getting 130 earlier.
my lord, that's why
He has to start at the bottom of the applicable to the promoted post.
in the case of the petitioner also, he started in the, a little bit ahead in the revised. I'll just show them.
On 23rd January 2017, when the man was promoted to the grade, the higher post,
Lordship.
the lowest pay band for the,
It will be either 12,000 or 30.
no, it is,
Either revision or non-revision.
no, forget about
12,000.
revision.
My lord, take 12,000.
Because it is not yet revised that on that day,
12,000.
it will be 12,000. Okay.
No issue. That's-
Moment it is 12,000, going by the formula of page 33, it is plus 5,900
Lordship.
plus 1250.
Hmm.
He's getting 19,150.
Because that.
So- Whether he had given him or not given him, we are not concerned. He's entitled.
He is getting PSP. The question
No,
is.
no, we are not,
for fixation.
we are,
That is what, my lord, I just wanted to show you. Lordship. Just for my, that I'm trying to understand.
where is the law of fixation? The formula of fixation. Please show us the formula. If the formula is right, we don't know, we'll take note of it.
That's it.
Somebody adopting a strange formula, that doesn't mean we'll have to accept it.
Lordship, why not we know?
Which page? Let us see. Page, rule 11. Shall be made as per FR 22-1.
One increment in the lower.
Huh?
Then. After. In case of.
Just a minute. So now it appears
Lordship.
fixation of pay on promotion, just a minute. And so therefore that clause 2 you are increasing increment of 3%.
Lordship.
So 22(1)(a) provides 3%. So FR comes down.
My lord, it provides 3%.
Let us take a look at the FR.
FR 22. 1A rules.
Mhm. Twenty-two one.
1A1. my lord.
22(1)(a)(1).
Where a government servant holding a post other than a temporary.
If he holds lien on a permanent post other than a 10-year post. Yeah. Huh? 22(1)(a)(1). 1A1, we are reading that only.
The initial pay of the.
It is not applicable, something wrong with the ROP rules. If he holds a lien on a permanent post other than a 10-year post, then what I am reading then? How can there be two FR 22?
Books, just that book, my lord, gives my.
So book is wrong.
I know, man, there is some provision. This is the old one, but old is good.
No, you are reading,
22A1.
no. This is 22.
A1. 1A.
সেইখন চাওঁ। Both by the same gentleman. And Mr.
This one.
Nair,
Lordship.
in that book also, there is FR 21.
This- There is an amendment, my lord, it was amended and then that is the.
No, this is part of Rule 21.
That 22(1)(a)(1). My lord, is what is being. applied.
See, what I have read 22(1)(a)(1) is also appears in your book also.
Lordship.
Kind of. When the law, when the provision is clear, 22(1)(a)(1), why should I go to something else? Provided within 21. That is a clear 22.
Okay. It's like that 4D equation. Unless you have not checked it out, ask me that question. I never have gone to my lord, Article 320 or the opening paragraphs of that. My lord, limitation 51 regulation. Only after my lord said that I ignored.
Even 3F is also appearing like that. Other day I got a matter of 3F. No, other day I got a matter of 3F. Almost the same problem is there in 3F also.
My lord, that Sumi Dubey, my lord, has already helped. Not being, it's a limitation. Did not even go to my lord, APSC. My lord, remember.
I think the other matter is yet to be decided finally. I think it's pending some other way.
My lord, I got it, my instructions to be a little bit unclogged.
Okay,
My
no.
lord, let me also, my lord,
Definitely apply a matter. We are not imposing anything on anybody.
because my lord, what's
See,
happening is this will have some ramifications.
what our concern is,
If he is entitled.
if some employees are entitled to a benefit under the law, they should be given.
Lord,
If you are not entitled, reject it.
But my lord, only my request to my lord is to my friends. my lord, let him also, my lord, get that, how this is being done, my lord.
Yes,
That will
Mr.
be-
Gogoi, you also
because-
please help us.
Because that PSP thing is creating problem, how they are
But
handling.
PSP, what I understand, it's for all time to come unless it is withdrawn.
No, it should be
And,
there.
and formula is very specific.
Lordship.
Pay
Whether-
band, grade pay, PSP,
I
added
will give-
together the
I will
basic
give
pay.
Basic.
So in every revision, in whichever pay band the band
This has to be.
gets into, that will be the pay band plus that grade pay plus the PSP. Hmm. As for the payment, definitely. So whatever payment is applicable, that one, you cannot apply a different payment. Huh. No, again, the word fitment is the most dangerous word I find.
That is the changeover and all. That is said to be the main. Without that, why are we being-
When they will speak about the payment. The lordship may now even, the top lordship will see device speaking with payment. So this is the payment. Same as I was responding. Again, pays everything. Here, my lord, in para, either will state it, basic pay. Basic pay.
Uh-huh.
Well, paying the payment. Grade pay.
Where are you reading?
Base 33.
30?
PSP.
3. Huh.
33.
Paying the payment plus grade pay plus PSP.
Hmm.
You have to consider the payment. Madam. For my lord, the different table will have, you have to consider the payment and the grade pay only. Of the PSP. Base what?
Okay. So that will be 17,900. Huh. No, no. So now 17, no, just a minute. 17,900, you take it, you fit him there. We have no difficulty. But 17,900 is the basic pay. But the formula gives basic pay, you'll have to add the PSP. No, not after fixing. On the basic pay, that's a
Basic
difficulty.
pay. And I received that prior to fixation.
On the basic pay, you are right. For the time being, we don't take PSP. Then this man comes in serial 1, 17,900. Admitted. But if you go to base 33, you'll have to add the PSP. Moment you add the PSP, he comes to 19,150. Moment he is 19,150, he is serial 4.
The 91, the basic pay.
Basic pay.
For my understanding, the different table is the grade pay only. My lord, the payment only. That's what I'm trying to.
Yes, even if it is so. No. No, so where is, understand. So if you take that view, then how you are giving the PSP? I accept. Mr. Gogoi, what you are saying, I accept. But how will you provide for the PSP then?
PSP is provided. When they pay is fixed. Page 40.
Huh. You cannot add the PSP to 43,000
It is.
because PSP has to be basic and 43 is the total pay,
No, not total payment. It's basic pay.
right? See, total pay.
Total pay means, man, it's a basic pay.
No,
Yes, man.
no.
Manoj will not have any, man, the Manoj
No.
will take it from me.
No, why you see, read on top, revised pay band is 30,000.
Manoj, this is not his take home pay, man.
No, definitely.
No, 43,300 is not his take home pay. It's not his take home pay. This is the basic pay, which after revision he has been given. 1250 will be added to this. Thereafter, that would be his basic pay for calculation of TA, MA, HRA, etc. This is not the home take home pay.
This is the basic pay.
This is basic pay for the power purpose of revision. Thereafter, when he, my lord, his other benefits are calculated, 1250 will be added to that.
Understand? But what is provided in the left-hand column?
Left-hand column is his unrevised
Basic pay.
basic pay.
So unrevised basic pay will include PSP. So when you make a comparison, it will be related to the unrevised basic pay including the PSP. So whichever he gets into, correspondingly, he'll get
Why
into
not we
that.
have the top portion of that also? That's what Bamala is creating problems. That has to require a resolution. I'm not on an answer. But that's the question Malad is coming.
But
about.
just a common logical
Malad, if
thinking,
it goes by that, I have nothing to say. But Malad, I have to accept.
but
what
other,
the petitioner is saying.
but otherwise, if by a notification and after a court judgment, a formula is given.
Malad, that's what I'm trying to explain. Page 54 is a RTA.
Replies of one man, we are least interested. We are on the actual interpretation.
It's correct. There is no dispute on that. Malad. Said, a person who is appointed to a particular post, that is grade what would be his basic? They give a reply that it will be 19,150. Lordship, this is an internal matter for us. This is an internal matter for the High Court. Now, when the revision comes, we are not doing it. We are doing it in terms of the
No,
principles laid down by the-
Mr. Nair, we are not only hearing we and they, we are hearing everybody.
Malad, I'm-
The answer must be a collective answer.
Malad, please excuse me for my words. I'm just trying to get it out from my mind.
I understand.
Malad, please excuse my words.
If your submission is, it's a finance department who is providing, we are following, then we ask the finance department.
Yes, Malad, that's what I want your lordship to do. Malad.
Yes, we are already
Malad,
asking him.
We'll hear my query, my that apprehension. Now they have given us a rules. They have given us a rules. We'll have to apply the rules.
Rules is unreadable.
No, the rules, the ROP rules.
Clause 11.
Clause, no, my lord will forget the clause, but the whole group. It comes to us, we have to apply. Now, when we take up for the purpose of revision, we can only take pay band and grade pay. Because my lord, these 40 also,
Mr. Nair,
I'm on that.
Mr. Nair, our question is for any other employee of the government of Assam, you are 100% right. But because of the notification at page 33 for the High Court employees,
Whether that will be taken.
it has to be taken. If it is, once it is provided, if the law provides something, it cannot be taken out.
My lord, that's what I'm saying. PSP is an internal. My lord, I'm not saying that it should not be taken or it should be taken. PSP is an internal matter we are taking. When we are going for a revision, we are
See,
bound by them.
Mr. Nair,
But they have not provided for that.
no, in otherwise, by virtue of the page 33 notification, the employees of the High Court are in a different class than the other employees of
That
the
is
government of Assam.
When it was first said that you are going for the
So-
updated revision, I was shocked by it.
So,
There has to be an independent.
so if you are not gone, we'll have to implement what has been provided.
revision.
You cannot give a different meaning to it.
My lord, that's what they have to answer before your lordship.
What,
One question,
or,
one
or else another option before the government is you withdraw page 33.
page
Then the legal consequences will be examined. And that you cannot do, it is pursuant to a High Court order.
No, man. It's a decision of this court and that will remain.
It's a judicial order, you cannot do it.
The resolution now required is whether for fixation of pay, for all other benefits, my lord, they are getting that calculation.
So moment one set of employees are put at a different class by law,
My lord, here,
another principle that goes against you,
lordship,
a set of employees are put in a different class by a law.
lordship, they have to.
That difference also cannot be subsequently taken away by giving any other
other
interpretation.
My lord,
That class distinction has to be
my
maintained.
lord, that was not done. When he was working as, my lord, before that revision, 23,197, there was 17 and after. In May 2017, his pay was, my lord, 12. Grade pay was 5,000. His PSP was 1,300. That is that 19,100. A confusion, my lord, I also thought that was the final. No. Basing on that, 19,150, his DA was kept. which is around 25,080. And HRA of 28,773. There was some calculation error here. Subsequently, the areas were filled. So this block is for the purpose of calculating his salary.
Total money will be paid.
But my lord, when it comes to revision, there are different parameters which are operational. It would be my lord, when my lord finally decides the matter, my lord says that no, the revision also, this parameter has to be taken into.
Which parameter?
The PSP has to be taken.
It has
into
to be,
Well, that's.
because PSP for all purpose was not provided for only one revision of pay. That in future it will not be applicable. It was never provided like that. So, and it was provided for until withdrawn for all time to come. A formula is given how to calculate it. Pre-revision, post-revision, same formula will be applicable. It is nowhere stated that after revision, a different formula will be applicable. Apply the formula in the simplest of manner. Whatever comes out is the answer.
That's what madam they are doing. Which my lord is not acceptable by this honorable court is that when you are applying that principle for revision, my lord, for all other purposes, this issue is not there. My humble submission. For the purposes of revision, because in the fitment thing, you have, my lord.
Mr.
I'm trying to just take it out from my mind.
Mr. Nair, fitment is ordinary meaning of the word fitment is where will you fit the
My lord,
person.
it goes
So,
slightly beyond that.
No,
It goes slightly
you
beyond
have
that.
to fit wherever he is to be fitted, not wherever you want him to be fitted.
My lord would have rule 8.
It's a huge rule. Which one?
Rule 8.
Hmm.
8A.
A.
The initial pay of a government employee who is in service on 31/3/2016 and is entitled under these rules to draw pay in the revised pay structure shall, unless the governor of Assam by special orders direct, otherwise in any special case be fixed on the date he becomes so entitled, in respect of a post of.
So now we are relying on appendix 6,
No, appendix 1.
appendix 1.
Yes,
Okay.
sir.
Where is
Just
appendix?
let me in respect of post referred to as the below. In case of all government employees, the initial pay in the revised pay structure is to be fixed as per the fitment table in appendix 1. That is how appendix 1 has come.
Hmm.
So my lord, appendix 1, we can't go beyond this now because
Ah.
it's a 309 rule.
Very well.
Now, appendix 1, my lord would see in the pre-revised portion what is being taken.
Ah.
My lord will have the first one, table 1.1. my lord. First one, no problem. It's the same.
Table?
1.1. Oh, my lord will have the current table, which is page 40
Huh.
and page 334.
3?
In my book, 334. in my book.
Okay, we take that one.
That
Huh.
right.
Hmm.
Now, my lord would see first the stage of pay after 3% increase. My lord has got it.
Hmm.
Then here, the pre-revised, only two is there, ROP, payback and grade pay.
Hmm.
And when they fix it, they take only payback and grade pay.
Mr. Nair, again, we are pointing out to you, for any other employees of the government of Assam, you are 100% right. If possible for more than 100%, you are
This is the only.
even more than 100% right. But when the employees of the High Court have been classified into a different class,
Yeah.
make page 33 applicable to them.
Yeah.
You will have to
Then
follow
this-
it.
This
Then-
fitment table will
Ah.
have to be changed.
By applying page 33, if a different fitment or different
Is required.
required, you have to give that.
That's what my lord, my friend. has
You'll
done.
have to give.
But that's what I'm, in this.
And
fitment
you don't have to give anything beyond, because page 40 is crystal clear
No,
where this man will
This
come.
is without PSP. If PSP comes in, how the.
Again,
calculation-
Mr.
Why
Nair,
I'm saying so.
Mr.
Why we
Nair,
have- why we have that for my sake.
Mr. Nair, if we understood page 33 properly, you read it again. reading conjointly page 33 and all other general rules, the only conclusion to be arrived is that for that pre-revised pay, in case of high court employees, will also include the component of PSP.
I got it. But that PSP is not being denied. I understood what my lord is trying to say.
And number two, PSP has to be given as provided in page 33, not in any other manner.
But
And moment you follow page 33, this man will be PB, grade pay plus PSP. There's no other way of looking at it.
Okay. Now, what is there? Why-
I think you wanted a breather to think over.
No, madam, not a breather. No, I have to go in. It's just that unplugging took place.
See, all the problem is coming because
Because of that.
Because at some stages you refuse to recognize that there is a different class of employees. At some stages you recognize that they are a different. Where you don't recognize, you adopt something other, some other provision. Where you recognize, you provide something else. But consistently you will have to proceed on the premises that they are a class different from all others.
Unfortunately, this adoption, but this is nothing to do. This adoption will be an adoption. The revision is yet to take place for them.
Oh.
This is not the revision for the actual revision for the. There has to be a separate revision. This is a adoption given to the time being.
But as long as it is there, it is there. It may be.
It's a separate category.
So as long as it is being provided, either ad hoc or temporary or permanent, this class of people happens to be a class different from. So therefore, a few of the provisions applicable to another class of people, you cannot borrow, bring it.
But unfortunately, my lord, when that was done, I'm sure, I'll just check that up, my lord, when that was adopted for the time being, for the employees. So there was a revision. It would take how many years, God only knows. So, my lord, a benefit was given. Whether these issues were gone into, that's what I would like.
If not gone
My
into,
lord, we'll have to-
no, we interpret it the way it is
because, my
available.
lord, why-
Of
why-
course, government will have the liberty to take frame something different if you want.
That's what.
That is
That's why
something
I-
different, but as long as it exists, as it is existing today, you'll have to take
Because,
note of
my
that.
lord, this would not be limited to one person. It will be limited to benefit if my lord, as I could part my lord. If my lord grants this, then everybody from top to bottom will get it.
Definitely.
So my lord.
So we only want to know whether
This is. to be
under the
done.
law,
How?
they are entitled or they are not entitled.
My lord, I'll also, my lord, let my friend on that pointed query have a reply.
What was the query?
My lord, that whether PSP, my lord has held that it is to be done.
Page 33, I don't know. We are not held anything.
No, no, page 33.
Huh.
Now, whether, because now what the formulas they are sending us, it's not there. So the view they have and the basis, that much, my lord, they'll have to disclose.
One
Yes, what do you
small-
want to say?
While making fixation in grade 2 lordship, I was being provided, my basic pay was.
No, I understand. What she is trying to say,
Yes,
Mr. Nair,
7.
I understand.
See there,
Huh.
1,000 was there. in
Yeah,
my
I
basic.
understand. What she is trying to say, before her promotion of this man, this page 33 formula was made applicable. So there is no reason why after the promotion
Why this?
and why it will not apply the same formula. There cannot be a formula applied in two different ways, one before promotion and one after promotion. I think that's a very good logic being presented.
This did not pick, now it picked. I'll.
So now what query should I place?
Only thing.
I think everybody has understood what is the query about. Mr. Gogoi, I think you also understood what is the query.
My
You
lord, please
come
refer to
prepared.
page 33. And my lord,
37 is very
let
clear.
them put before your lordship as to why that was not being applied. That much would.
The respondents in the finance department may examine as to why the formula presented in the second paragraph of the notification dated 16/6/2016, page 33, annexure 4, is not being applied in the manner provided after the revision of the scale of pay.
No, ma'am. After the revision, it is being provided. Why not being said for the purpose of revision?
For the purpose of revision.
Because page 37 is very clear.
The list on, when do you want, Mr. Gogoi?
No,
list
no,
on.
not for that.
Heard in part, list further on, so it's.
Lordship.
Yes, lordship.
Immediately. No. 7 no. 7 no.
Yes, sir.
Okay. Yes, Mr. Mayor.
Very clear with like
Whenever
this.
she is there, my lord.
Mike, I'm very,
Issues are very, it's a simple issue, my lord. But the tsunami therein is very big.
my lord, always with my thing, I'm clear with, in my mind, and whatever calculation is done in grade 2 has to be same thing. has to be-
Unclear for you.
Perhaps, Mr. Nair,
There is so.
even after promotion, you cannot adopt a different method. After revision also, you cannot adopt a different method.
That's what I.
What is going on in the same manner? And if you want to withdraw it, revise it, you are always free to come up with a new notification that will be tested.
They can't touch PS. Only thing they can touch is that fitment tables and the rules.
No, that formula.
Formula.
It is concurrent. And you're holding the field, that's a difficulty. It's yet to be taken out.
Deeply agree.
Production list item 1.
Which one? This one? Oh, very good.
9.
Got something? Have you got something which you can give a handle to the court to pass an order in your favor? We are making the most open offer to you. But without repetition of what you have stated. Because some other litigants are waiting, we have to give them a turn.
My lord, it's not my submission.
But perhaps we cannot. The whole difficult, Mr. Borguia, is that Supreme Court one. That's why I'm asking him a question. This is the third round or this is the beyond third round? He says beyond third round. Supreme Court says after third round, you cannot do anything. That's the biggest obstacle in your entire effort.
Yeah, my lord, we are not given third round, my lord, properly. My lord. Because one man, my lord, entered, my lord, we.
If you are not given third round properly, what can I do? You should have come immediately when third round was given to you. When was third round held?
8/10/2020.
8/10. Today is. Third round happened on 8/10.
Yes, 10.
What happened in the third round?
Third round, my lord, one, my lord, man and woman, my lord, entered, my lord, serial number 284, my lord. He is not,
That Mohanto.
yes, my lord, not in service.
They have been, my lord, admitted prior to the third round.
Hmm.
Maybe in the first round. itself
Yeah,
they have put-
true.
Thereafter two.
My lord. Till, my lord, third round, my lord,
Sorry.
it is changeable, my lord.
It will be difficult, Mr. Borguia. What you are submitting is the entire list, entire admission made. Everything will go topsy-turvy.
My lord, only, my lord, our, my lord, in service candidate quota, my lord.
So you're right, legal right.
Only,
The
my lord,
petitioner,
Lordship, just kindly have a look, please, my lord. This is, my lord, page 80. If she is not there, my lord, petition number 4 would have been at her place, my lord, on third round, my lord.
Mr. Borguia, you have stated that at
Yes,
least
sir.
15 times till now. Same thing. But it's difficult to accept the manner you are saying. You have to go by the law also.
But here, my lord,
You go to the parliament, amend the article to 226, that the High Court has any power to do anything it feels like. We'll pass the order. But we are bound by the law. What can I do?
My lord, had they, my lord, this candidate was in service, my lord. Because-
Anyway, third round is over. You are trying for the fourth round. On that ground, we cannot entertain. The petitioner seeks to raise an issue. That serial number, what is
Serial
that?
number
Some
284.
24, you say, 824.
284, my lord.
280, that serial number 284 in the provisional list of selected candidates for the postgraduate course, namely
Page 83, my lord.
Aradhana Mohanto.
Aradhana Mohan.
Please don't go and interrupt me. Namely Aradhana Mohanto. Your pronunciation and mine may not be same, but we are saying the same name. So don't interfere in everything.
Hello.
Aradhana Mohanto, who was allotted a seat under the SHQ in the subject MD Pediatrics, is not entitled to a seat under the SHQ. And this had resulted in an aberration by the respondent authorities while allotting the seats. And the petitioners belonging to the SHQ category would otherwise have been entitled to the seat allotted to serial 284 Aradhana Mohanto. Mr. B. Gogoi, Learned Counsel for the Medical Education Department, upon instruction, has provided the information to the court that the candidate Aradhana Mohanto had not reported for the purpose of admission, although a seat was allotted. The submission of the petitioner as to whether Aradhana Mohanto was entitled to a seat under the SHQ remains undecided as on today, apart from the submission of the petitioner that she otherwise would not be entitled. According to Mr. B. Gogoi and Council Medical Education Department, the seat that was allotted to Aradhana Mohanto would have to be constituted to be a vacant seat available with the authorities. Although the reason why the candidate did not appear for admission remains unclear without the matter being decided. Secondly, reliance is also placed on an admission notice dated 8/10/2023 of the Director Medical Education Assam, wherein in clause 7 it is provided as extracted. Clause 7, in pursuance to order of the Honorable Supreme Court dated 22/7/2022, provides that the candidates who had joined in any of the courses to which they were allotted up to round 3 shall not be eligible to participate in any further round for the All India quota or the state quota. Admittedly, the counseling that is presently going on is beyond the third round. Accordingly, it is the submission of Mr. B. Gogoi, Learned Counsel for the Medical Education Department, that even if it is established by the petitioner that the vacant seat allotted to Aradhana Mohanto was incorrectly allotted, if she did not belong to the SHQ quota, from the point of view of the present petitioners, it would be an endeavor to participate in a further counseling beyond the third round which would be impermissible as per the judgment of the Honorable Supreme Court, and therefore the respondents are unable to accede to the request of the petitioner. In view of the above, issue notice, returnable on, we'll hear you again. So and so. The respondents may file their affidavit on the aspect. We're given a reason.
Production list item 2.
That's why I gave you time to reflect. If you find something, you tell us beyond this, but without repetition. এখন লাগিব নেকি কোট কৰিব Yes, Mr. Saikia.
In this case, the petitioner Vipul Orsi was initially appointed as LDA.
As
As LDA, my lord.
this is not medical,
No,
he is demoted.
yes,
Which order?
by order, my lord, at page 40, my lord.
40.
40.
The petitioner is
Amal
Amal.
Kumar Das.
Amal Kumar Das. Was Amal Kumar Das heard in this order? Doesn't appear so. Sorry,
Page 7, paragraph.
something is there.
Yes.
Page 7.
Page 7, paragraph.
So not a good language. In view of the amendments made in para 7 of the writ petition, the writ petitioner to show cause as to why contempt notice should not be issued for using slanderous language against the court. Next item.
I'll reply, my lord. I'll permit to-
Up to you. No, you wanted today itself. We have heard you. You've gone for an unlisted motion with saying that this thing, how can I allow you to withdraw now? You give a reason next day. List on so and so.
Against that, my lord, order. my lord,
List on so and
the
so.
appeal
It's
is pending before the Kannaught court, my lord.
whatever it is. First you show cause this one, petitioner. We have not issued contempt notice. We are asking you why we should not issue contempt notice. Yes, next item.
Well, I will permit to-
Refused. Yes, ma'am, sorry, possibly you could not pick up the matter. Oh, wow. Do you have any urgency? What kind of urgency?
He's out of job, my lord. He joined as a chokidar and served for nearly 20 years. So, my lord.
Are you telling me?
Tuesday,
Tuesday? Tuesday. But Monday, I'm told there's a long list already there. Tuesday, okay.
my lord, I will file an affidavit, my lord, tomorrow, my lord. Take
Do
up the
whatever
matter
it is.
tomorrow, my lord. You take up the matter tomorrow, my lord. I will file an affidavit, my lord.
Next. The dates, please take up. Because next week also we have hardly 2 days of working time. Thursday, we are not available, Wednesday for a very less time, so practically on Monday and Tuesday, so whatever can be accommodated. Unless it is extreme urgency, we don't intend to get it listed. If it is extreme urgency, definitely we'll take note of it. So, my request to all the learned council, take a conscious decision of your own. If it is extreme urgency, please tell us. If it is not extreme urgency, bear with us.
Item number 2 may be taken tomorrow, my lord.
No.
I'll focus that
No, sorry,
tomorrow.
definitely not. It's too bad a language. You're slandering the court, single judge. If a single judge had issued such kind of order, you ought to have gone for a review of that order, recalling that order. That without hearing me, this was passed, or even should have gone for an appeal. But you have no business in another writ petition, you'll be slandering the court. Sorry, we don't agree. And we don't encourage this kind of proceedings. Everything as per convenience of everyone. Only a conscious decision unless it is extremely urgent, not next week. And if it is extremely urgent, tell the reason, we'll do it also, accommodate you.
I never appeared directly before the court, my lord. But in the judgment,
Okay. Very well, issue notice, admit Mr. G. Sharma, Land Counsel for the Home Department, MSLDV for Union Dominion, Mr. A. Ali for the Election Commission takes notice.
Otherwise, it is an expert order, Lord.
Understand? So he said he never got notice. Call for the,
appeared, my lordship, on my behalf, Gagura, one Gagura at that time, he appeared, he did not communicate what happened in
no,
the.
no, call for the records.
Yes,
I
okay.
admit, call for the records.
In the meantime, interim, my police is searching me, my lordship.
Definitely they'll search you.
Yes, my lordship.
Why don't you go to
Also
the,
that,
why don't you go to the tribunal, get it adjudicated?
Lord.
Appear before the tribunal.
and
The
10,000
pendency of the review petition shall not bar the writ petitioner from appearing before the tribunal and getting the matter decided on merit.
And also, my lord, that 10,000 rupees, my lord.
Will hear you.
Highly obliged, my lord.
You go to the tribunal, appear, because anyway, you'll have to go to the tribunal.
Okay, my lord.
If we have to set aside this ex parte order, it has to, you have to go back to the tribunal. So this reason or that reason, you want to be set aside or you don't want it to be set aside?
That-
Or you want ex parte to be retained?
No, no.
Don't want. Then you have to go there. Regarding your 10,000 cost, we'll hear you on review. If actually you, no notice was served, you never appeared, we'll recall the 10,000. Okay. Cost imposed, we'll recall it, but on merit, you will have to go and get yourself discharge the burden.
Deeply obliged.
List কেতিয়া কৰিব? List again.